Yes.
May I have your lordship's leave to file this memorandum of appeal without certified copy with server copy, my lord.
Order dated
9th of April, applied on 15th, my lord. I have attached the slip, my lord.
normal period of limitation expires. We never gave a single leave to
My lord, it's a leave to appeal, my lord. I was person
file
came.
it. No leave to appeal.
My lord, I applied on 15th,
Maybe,
9th of
maybe.
April
You
order.
get the certified copy and come back. Yes.
May I mention one matter yesterday when it was taken up, my lord had directed my junior to call the advocate on record. That was item 13. The very next matter was also mine matter, which was unattended due to that. And it got dismissed for default.
What can be done? We have signed it.
The order is not in the server, so I thought it was not signed.
I think it might have gone to my brother.
Very well. I'll come back with a restoration.
Item number 49, my lord. I am paying only not this week.
Why?
So my senior is ill.
Yes.
Only not this week.
Senior ground.
Sir, kindly
No
accommodate.
ground.
Sir, kindly accommodate.
Senior ground on a senior's
Sir, kindly
ground. No.
accommodate. Only-
Why don't you do it? Do it.
Sir, kindly not.
That's an opportunity. You will get it to move.
Client has engaged him, my lord.
Let us see. At the time of call.
May I have your kind leave to mention one application for inclusion, Your Lordship? Grateful.
Your Lordship, may I have your kind leave to file this memorandum of appeal without the certified copy?
When order was filed.
24th of June, Your Lordship, we have applied yesterday. Grateful.
Item number 1 to be mentioned.
So, order for still. Sitting aside abatement. The matter has come up by way of an assignment from the Office of the Honorable Chief Justice. There is no appearance on behalf of the parties. Let can 4 of 2023 be listed after 2 weeks.
Item number 2.
This one of applications কেন দিচ্ছ না তোমাকে একদিনের জন্য বললাম তুমি প্রত্যেকদিন ওল্ড ম্যাটার্স গুলো রেখে
কিছুই নেই টাইম চাইছি না আমার ইয়ের মক্কেলকে তো খবর দিতে হবে
ম্যাটার্স গুলো
না দেবে না মনে হচ্ছে নাকি
না absolutely because application
আমি রিটায়ার করছি
urgency হতে পারে yes
item number 2 this matter I am for the writ petitioner respondent my lord the old matter of 2014 my lord I have no contact with my client my lord lordship if your lordship desire lordship I am praying for at least 2 weeks time my lord
what
my lord
this matter is pending for a pretty long time. It is appearing in the list for a pretty long time.
Yesterday I came to learn that matter
What
is
came to
listed
learn?
from learned senior friend, my lord, that I am on, my lord. I have no contact with my client, my lord, lordship. Otherwise,
This is not expected. Because this is of 2014 answer
yes,
script,
no,
5
14
marks,
answer scheme matter.
everything. Now is,
Whether
he
she,
may not be interested.
yes, whether she is interested or not, my lord, only one day accommodation and, my lord, difficulty is that no phone number with me, my lord. So that for that reason, I'm paying my lord 2 weeks time, my lord.
As my
I
lord.
think it has virtually
Ah,
become infructuous.
Yes,
Infructuous, because my lord, your lordship will kindly see, if the appeal is said to be infructuous, then my lord, the London single judge order will prevail.
No, infructuous means he may not be
Yes,
interested.
my lord, that is
Ah.
there because my lord, he has my lord, stated that she is a teacher nowadays.
কোথায় বলেছে কোথাও?
Paragraph 2A.
She's already a teacher.
He is already a teacher in a school, man.
Then I think
It is there. It is there.
Paragraph 2A?
Did we say paragraph 2A? It is there.
if the 5 marks is given to you, how it will materially change your life?
Thing is, my lord, in 2010, she could not succeed in mathematics. In 2011, she
Hey,
scored only
মেরিটে তো
in mathematics.
ম্যাথ মেরিটে
In 2012, she scored only 19. My lord. And my lord, after
And
review,
thereafter she passed.
no,
Then how she is working?
my lord, it's a part one, my lord. He is in a primary school, my lord.
Okay.
Primary school teacher.
So eligibility, educational qualification is?
They are, my lord, Madhyamik or 12, my lord, as the
Yeah,
case
yeah.
may be. Your lordship.
I have no
This
instance.
is related to,
কোথায় লেখা
it is
রয়েছে?
in relation to an undergraduate.
Yes. Your lordship kindly come to 2B.
It's an
Page 9.
undergraduate.
Undergraduate. Page 9, paragraph 2B.
স্কুল মেমোরি বর্ধমান 2B. My lord.
What to do?
My lord, I am paying my lord.
Counsel for the respondent number 1 submits that he has no contact with his client since long, and therefore the matter may be adjourned for 2 weeks to enable him to take instruction. In view of the above, let this matter be listed on. Today is 9th, 23rd.
As my lord.
If 5 marks is allotted, she will pass.
No, not that much. Even then, the position is, my lord.
No, I am asking.
Pass.
It's only 5 marks matter.
Yes.
Suppose if it is allotted to her, will she pass
Yeah,
the
that's
subject?
why
You would not be able to complete his complete her graduation. It's only part one.
Oh. So the next
Item number 4.
পাস করে গেছে।
week কি হলো?
Your Lordship, on behalf of Dr. Sutanu Kumar Patra, I am
Last-
praying short.
Yesterday also you asked for a time.
Yes,
Today also.
engage before courtroom number 18.
Sorry.
Admin matter is going on.
Sorry, we can't.
But I am only playing
We
short
can't.
pass
No,
over,
sir.
my lord.
Sir, we have accommodated you thrice. Every time we are sitting.
My lord, I am humbly praying
There
before
is
your
a senior
lordship.
bench. This is I believe is a senior division bench.
My lord, my
And
lord,
fairly at the top.
my lord.
Sorry,
I am
we are harsh, but sometimes you can't encash our modesty, our leniency.
Lordship, item number 1 is going on before
Sorry, we
courtroom
can't.
number 18, my lord. Assigned matter.
You ought to have said yesterday that tomorrow please do not fix the matter. No.
I am humbly praying kindly fix at 12.
We are harsh. I
Humbly
know
praying.
we are very rigid, but still sometimes we have to be very rigid. We do not want that the member of the bar at his leisure time will come and argue, and the court has to sit or wait for him. No. I think the control of the proceeding is with the bench. Sorry, you can't take. Thrice we have accommodated. You are taking an advantage of our leniency. No, sorry. That shows that your client is not interested. Same submission. Right. 3 times he is coming and asking, he's engaged in another court, please grant me a time. No. There must be a limit. Somewhere one has to stop.
Again, my lord, I am humbly praying, my lord.
No, sir. Again we are rejecting it, sir. Again we are rejecting. Where is the improved order? 26. Sorry. Sir, tell your junior not to say something. You mention the matter in the morning and then he says he's engaged in such and such court number.
Yes, I had item 1. I went and I
Sorry.
just came back. That
Should-
two items.
You should at least make your junior ready for that matter.
My lord.
This is not expected.
My lord. কোনটা আগে ধরেছি? পরের নামটা বল। সুস্মিতা তো ঠিক আছে, very good. My lord, this matter.
One minute. Where is the writ petition?
সুস্মিতার পেপার আছে। পেপারটা আসেনি। সাথে রুলটা বার করে
Is she still working in that school?
whether
I'm asking you, sir.
uh,
Is she working in
no,
that?
whether she has joined, that instruction I don't have, because
This
once,
is what is more important.
yes, but that instruction, the commission,
This
will-
is a matter of 2014.
yes, after we recommend, then whether the candidates are joining or not, that instruction, that information we
Sir,
don't.
This is what the first and foremost information we should give. We are conscious that this kind of a mandamus should not normally or ordinarily be issued by the court. But what we wanted is whether there is, go and ask.
My lord, this information will not be with the commission. Why I say after we recommend, whether the candidates are joining,
Appearing for the board. Board is a party here.
My lord, at that point, the board was not the appointing authority. The school was the appointing authority.
The situation may be by this time, she might have applied for a transfer and the transfer has been effected.
Yes, that possibility is there, but what has
What I
happened?
wanted.
But as far as the order is concerned, once the candidate has selected the
I
school,
have seen that. She says under the misrepresentation, somebody who was there misrepresented.
hello, that
it
is all her
in Barakpur or
paragraph 3 of the writ petition.
Parasat, and it appears that it is
No,
there in Patwa.
But in paragraph 3, what is stated, that is not the correct facts. That is not how counseling happens.
Why you did not file an opposition there?
But,
You did not.
no,
You chose not to. Your
no,
state was
this order
represented.
was passed in our presence. Kindly see the order.
Sir, the state was represented.
Yes, but the commission was not.
Why? After service, if you chose not to appear, then in that event, where is the wrong? Doctrine of non-traverse will apply.
So that,
All these allegations
where-
goes uncontroverted.
yes, that is correct. But
See,
whether at all it was served at that point of time,
Why
also, I
not,
don't
sir?
know.
I don't think so that there can be any. You have
Well,
not
I'm not really on that point, whether I was served,
give
the
me
commission
an
was served.
instruction at 2 p.m. What is the status of this lady?
Very well, I'll try to inquire.
What is the
At
status?
2 p.m., I
At
have
2
one
p.m.?
fixed matter, my
Sir.
lord. Very well,
You just give me that instruction.
very well.
2 p.m. In the meantime, just tell us whether she has joined
Very
or
well.
she has not joined.
Next matter. Very well. Adjournment, please. Judgment.
Item number 5,
সারা সারা বান্ডেল তাহলে পিটিশন মাই লর্ড উজ্জ্বল মন্ডলের সব কাগজ আলাদা
লিখতে পার করো ঠিক আছে জিতে খেতে হয়নি কাউন্ট করো না সেটা কি আছে
What is this matter? Item
Lordship.
number 5.
In this matter, my lord was kind enough to direct Mr. Shubhi Shandal to take instruction whether the similar persons were given chance to shift from B.Ed to DLED or not.
Lordship, I am for the appellant led by Mr. Shandal. Mr. Shandal engaged in court number 18. Lordship, kindly give me a short pass over, Lordship. Give me
How short?
5 minutes or 10 minutes.
5
Lordship.
minutes. You will have to appear. 5 minutes. 11:05 you call.
রেডি থাকো রেডি বসে পড়
Yes,
item number 16,
দেখি শুধু অ্যাপ্লিকেশন কোনো দাও দেখি What is this scan 2? What is this scan 2?
Can 2. Can 2 was a section 5 application.
But that is appearing. It has not been allowed.
Can গুলো কোথায়? Stay petition, can 1.
No, can 1 is a section 5, sir.
Can
You have
1
not read.
Yes.
Can 2 is the stay application.
You have not read.
My lord.
Can 1 has been allowed on 26/9/2023.
Yes, yes, it was allowed.
So, stay continue. This is the 10A matter,
Yes, yes.
that
yes.
notification.
Yes. The scrutiny whether your lordships have given us 3 judgments, which I have gone through. Now this,
The thing is that what we could find, that is what is given.
my lord. But these judgments, may I just submit like
But
This-
there is one judgment which we have kept it, that has been, no, you are supposed to give a reply.
Yes,
That matter,
my lord.
earlier matter, yesterday,
Yes,
Mr. Sahara, this is that matter.
yes, yes,
That
yes.
matter, Mr. Shara concluded results.
Yes, so three judgments your lordships had given us to go
Which
through.
I come across.
Yes, so two of them, they relate to the post-publication review and scrutiny. The other one, is also post-publication, but where it states this Ranvijay Singh, this is,
B.R. Ambedkar's judgment, then Prakash, two I have given.
yes. Yes. Now, those relate,
Only in relation to what is the meaning of the word scrutiny. What does it mean? That's the only thing.
my lord.
Nothing more than that.
No.
Don't go post scrutiny. I just wanted, that is a judgment which I could lay hand to it, that what is the meaning of the word scrutiny and what does it mean? That's the only ground on that I have given.
My lord.
Is whether it is a re-evaluation, rechecking, reassessment, whether that comes within the purview of scrutiny. Why not review, re-evaluation? Those words are there.
But
Yes.
each authority gives a different direction to its scrutineer, its examiner, its head examiner. Here, the direction was specific that you are authorized to correct the overmarking and the undermarking. So it included, and in many other authorities,
That is why the interpretation should come, because the last clause 3, the overmarking and undermarking,
yes,
you have not said anything that what he will do.
yes, correct.
Ambiguous word. I believe, where is that? Yes, come to page 60. First thing is very interesting, which I really wanted to flag. There are two issues, because I have seen, first thing is you talked about the review. And then you say that with reference to a practice of the Public Service Commission, railway recruitment boards, etc., means the others, regarding the review of answer scripts,
Yes,
and also the view upheld by the division bench. Division bench did not say what is to be done.
no,
Then you say the answer script of the candidate shall be examined by the examiner as per the model answer provided to him. No problem. That's the mandate on the first examiner who is
yes,
checking or who is evaluating. Then supervision over the set of examiners in as decided by the respective regional commission, means there will be a set of examiners. During the evaluation of the answer script shall be conducted by the coordinator, and the points raised by the examiner, if any, be clarified by the coordinator engaged for the purpose. Means answer scripts, supervision of the set of examiners, means there is a surveillance or supervision over there. If the examiner has raised certain issues, maybe in relation to a model answer,
yes,
then it's the coordinator who will be there. His decision is final.
final. And will be uniform for the set.
Absolutely. No difficulty, sir. Then it's the most ambiguous. Then checking of the marks of each answer and its posting in the top sheet be done by the scrutineer, and he or she authorized to make correction for any overmarking or undermarking to any answer if so required. Now, how to interpret it?
My lord, this gives the scrutineer two separate powers. The first part is checking of the marks of each answer and its posting on the top sheet. This is the first duty of the scrutineer. That is the, what should I say, the traditional meaning of scrutiny. That he checks the answers, the addition, and whether they have been correctly put in. His second duty is to balance the marks with other scripts. So that comes in the second part, which says, and he, she be authorized. So authority is given to make correction, to rectify, that would be, for any overmarking, undermarking to any answer. So if he has been, any candidate has been given excess marks or has been given less than deserves, then that is the overmarking or the undermarking which he will do to keep a parity between all the candidates so that there is a uniformity in the assessment process. This is the function of the scrutineer as per the resolution. And I had submitted on the last day also that
He has flagged an issue that there is a regulation, there is a rules. The rules relating to conducting the examination.
yes,
The rule does not provide any kind of a mechanism.
no,
he says
pre-publication,
that
any
this is-
activity is
Understand, you were not there, sir. I do not know whether your junior has correctly communicated to you. What he says is that anything which is to be done must emanate from the power given in the act or in the rules. Something which is not there in the rules, that cannot be done by an authority. And that is why the liberty was given to challenge this particular notification or this kind of a resolution or whatever. The court has found that it is beyond the conceivable source of powers which has been assigned to you. So in that event, the court has caused this.
yes.
So only argument which he has advanced is whether this can withstand on the parameters of the rules and the act.
Yes, here my reply is that had it been a post-publication scrutiny where the candidate applies for the scrutiny or the review, candidate on his own volition comes forward and says, I want a review or I want a scrutiny, then it is required to be in the rules. Or else how will he know? But any activity prior to publication, that is normally never put in the rules. What is simply put in the rules, which I had placed on the last day, that is sub-rule 5 of rule 12.
This is what he says, the sub-rule 6, the sub-rule 7 is also required to be seen. If you come,
Then in that event, my engaging coordinator is also not mentioned in the rules.
True, that is what he says, that everything has to be done, because he says that what is the meaning of the word notification and what is the meaning of the expression prescribed. There are two expressions used in the act. One is the notification, defined, and another is the prescribed in the rules, by way of rules. Does not. So anything, if you want to deviate, what he says is, has to pass through that muster of by way of notification or by way of prescription.
আবার বন্ধ করে দিয়েছো হ্যাঁ
Do you have the photocopy of those acts? Because you were having one copy, big book, and then you took it back. Give that. We remember the arguments, everything we remember.
Sorry, man, can take up the book.
Why don't you get it photocopied and give it to us? Then we will not consider all this.
Sorry, man.
And these are not readily available in the market. One has to go with this book. It must have manual. At a school code.
Volume 2, page 951.
Same boy.
Same book.
No, volume 2 to dao. Aru dao, volume 2. Nahi. The boyta, the pataka দেখুন. Same state, 956.
টাইমটাই মেরে দিচ্ছি।
বইটাও আনতে পারে না।
Yes, take it back.
এটা
Got the-
আমাদের বই নয়, আমাদের বই জজ সাহেবের।
দিয়ে দাও, দিয়ে দাও। Yes.
নশো একানব্বই।
I do not know whether your junior has, you have the copy of
Yes,
the,
yes.
of the act,
So I'm kind.
Act,
The act I do not have.
School Service Commission Act.
Actually,
Come to page 936 first.
936.
Come to page 936. G, he says the notification means a notification published in the official gazette.
Yes.
And then he took us to
17.
I'm coming. No, he was referring that particular power to make,
Rule 17, section 17.
section 17 does not find that.
Power to make rules.
That's the section 17 is a recommendation of candidates for appointment to the post of teacher. Which 17? Right? 17 is that. Where is that 17? Which page?
Page 943.
That is another act, 943.
That is the West Bengal School Service Commission Act 1997.
Then what we were reading?
Starts at page 935 of volume 2.
Oh, we were reading.
935 of volume 2.
Yes. Yes, Lord. This has come to 17, power to make rules. It says that the state government, not you, may by notification make rules for carrying out the purpose of this act. Then he says, come to D. The terms and conditions, the manners and the scope of the selection of the persons for appointment to the post of a teacher under subsection 1 of section 8 to make rules.
Yes.
What is this section 8(1)?
Manner
The
and
manner and the scope of selection of the person for appointment to the post teacher shall be such as may be prescribed. And then say the procedure for conduct of the business of the commission shall also be provided by the regulation. We are not concerned. So manner of selection as prescribed.
Yes.
Then the rule has been made.
Yes.
Where is that rule?
951.
This is 951 is the rule. Then come to page 954. Have you seen that? 954.
Yes.
Rule 7, manner. It says the selection to the post of a teacher shall be made on the basis of the results of the regional level test selection test comprising written examination conducted by the Central Commission, evaluation of the qualification, and the personality test of the cadre in the manner as provided in Schedule 2. Then Sub-Rule 2 gives you certain powers. Central Commission may in its discretion fix a qualifying marks to be scored by the candidate in written examination or to relax such and such. So that power is there. You can put say the 50% in each subject has to be a qualifying marks. And then come to Schedule 2, which is at page 973. It says that the subject to the post of headmaster or headmistress or higher secondary school or high madrasa or to the post of superintendent shall be made on the basis of the selection. We are not concerned. We are selection with the teacher. So come to page 975. Selection to the post of assistant teacher in a school and madrasa shall be made on the basis written examination 70 marks, academic qualification 25 marks, personality test 5 marks, appearance before the personality test board is compulsory. Note 1. The academic qualification includes a professional qualification for selection. All these things have been given. Now, question is that if the manner of conducting the examination as prescribed, then the prescription must be by way of a notification. And the notification must be published in the official gazette. If it is not, whether this kind of a notification, this decision or resolution, which really changes the pattern or the evaluation or something of that kind, whether that is permissible.
My Lord, to this, my submission is that from the same rule which we are now reading, the power has given me to decide how to conduct the written examination. So everything is stated here that there will be a written examination, how many marks it will carry, everything is stated.
Correct.
I cannot go beyond that. But how will I conduct the written examination? That is for me to decide.
No,
So
that is why
my power from Rule 12, Sub-Rule 5. Kindly
please come. If you come to 7, that is what troubles me at page 954. Rule 7.
Yes.
There is already a prescription is there as according to this Schedule 2. And then
no, Schedule 2 is simply that what will be the breakup of marks for written test, how many marks will be carried, for personality test, what will be this the allotment of marks, and the academic professional score.
That is there.
But the written examination, how to come to the result of the written examination.
Come to 12, what it says. Five, the Central Commission shall decide the procedure and the manner of conducting the regional level tests, selection tests by the respective regional commissions, and shall issue detailed instruction in this regard in accordance with the provisions of the Act and the rules made thereunder. Proviso is also Central Commission shall hold a meeting with the chairpersons of the regional commission before the instructions are issued. Here he has joined an issue also. Now this is a transgression. Said, look at the members who were present.
That was the board. The board passed the resolution.
No. That is what he says, that it is a Central Commission. whether there was a representation of all the chairpersons of the regional commissions. There is none.
That it is not on record maybe, but
No,
if
no.
it was not done, then the entire scrutiny could not have been done.
True.
Or the court
That is what he says, that you have done a blunder. You could not do it. You could not do it. If you read 5, then he says that 5 says in accordance with the Act and rules.
No, I am.
Then proviso is inserted that if you want something to be done, then it should be with all the chairpersons of the regional commission. And then he has taken us to this first page, at page 58 of the petition,
Yes,
and say that who were the members present.
yes, that resolution was taken by the board of the commission. So the board members were present. That was way back. Now, when the selection process was undergoing, then there must have been a meeting with all the
Must have
chairpersons.
been, will not
Then
do.
they
When
will
you
do
are,
it.
when you
Or
are
else
trying,
the scrutiny could not have
No,
happened unless it was communicated to
there's
them.
nothing here nor there.
That let me come back with that
No, sir,
document if it is
nothing.
available.
You can't improve the case the moment the queries are being raised by the court. Every time. You are an author, sir, you are an author of the document.
My lord.
We are conscious of the brighter side as well as the darker side.
But
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 is a very big question.
but no. But what I'm trying to say, we have relied upon 12.5.
That's all. We will say that there is nothing which has come out so far as this notification is concerned.
May I just place 12.5 and then your lordships will pass the order.
That's
Let
all.
me just place it. The Central Commission shall decide the procedure and the manner of conducting the regional level selection test by the respective regional commissions and shall issue detailed instructions in this regard in accordance with the provisions of the Act. Here,
Act and the rules.
and rules. Here, firstly, the power
Is
to
there.
decide
Sir, it
how
is
to conduct.
correct.
That
It
is
is
given
there.
to me under 12.5.
Correct. There are two limbs.
Now-
One is says that there must be in accordance with the Act and the rules. If
Now
the
the
rules are
question
silent,
comes,
Act is silent,
yes,
then you cannot do it.
no, the question
is-
comes that whether what I have done is contrary to the Act and rules. Now my responsibility is,
There are two things. Then Dr. Patro, may I go to very fundamental issues. You are a statutory authority. You are not supposed to do anything at per your whims and the peril. You are a statutory authority will act only in terms of the provisions contained in the Act. We have read in the law college. An individual can do anything unless forbidden by law. A statutory authority cannot do anything unless conferred by law. This is very fundamental
my lord,
principles we learn in this college. You are a statutory authority. If you are acting, then the source of power to do such must emanate. You cannot do it.
my source of power is coming from the first part of sub-rule 5. That you decide how to conduct the
Proviso,
written
then
examination.
proviso curtailed it. That if you say that this power emanates from this enabling provision, then what is the necessity of putting a proviso?
Yes, I am, with regard to the proviso, though I am not equipped with any document. Had it
But-
not been carried out, had the proviso not been fulfilled, then
Presumption.
not
That
presumption.
every
All
every
answers-
action, then what it lead to? Let us go very generalize it. What it lead to? That if the power is test from the statutory provision, then every act, though apparently not in tune with the Act, must be presumed to have been done in the manner as has been provided.
No, what I'm,
Is a presumption you wanted us to believe.
no, not a presumption. What I'm trying to
That
submit
is what is there. There, if it is given, then must have been done.
no,
but
not
there is
given.
no
No,
document for
I'm not saying it from that angle. I'm not saying that since it is mentioned in the rule, it was done. I'm saying since all the answer script was scrutinized in this manner in each of the regions, then That only shows that it was communicated or it was discussed with all the regional chairmen.
There's no presumption. There is no scope of presumption.
If it had not been discussed with
Because,
them, then there
because even a governor does not indicate or refer this because it was pre the advertisement. Says that in accordance with Rule 20, the rules up to 2007, as amended from that.
only allow me to show the documents.
Nothing.
Because
it's an appeal.
it must
an
have
appeal.
been done, or else this scrutinizing exercise could not have been taken up.
No. It's an appeal. Nothing.
Scrutinizing exercise could not have been taken up.
Anything more?
No.
Thank you. Concluded? এই বইটা পাঠিয়ে দাও আজকেই আমি দেখি আজকে কালকের মধ্যে ডিকটেট করব এই শুধু এই বইটা এক মিনিট ট্যাগ করে দিই give me that page number first, the act 900 and the act starts from 935. And the rules start from 951. Yes. Yep.
Judgment is reserved.
You wanted to dictate because it will take 1 hour.
No,
I
no,
can
I will-
dictate here and now.
There you go.
But I have gone through the judgment that was handed over to me on yesterday, my lord. All the judgment supports my case.
Huh?
Yes.
One does not. One does not.
Although
One
the
case
fact
does
is
not.
slightly different, my lord. Deeply obliged.
But I have kept all three in my list of judgments for reference when I need them.
Yes.
Deeply obliged.
Extremely. Deeply.
Yes, go. Call the next. 5 minutes যেটা আছে কল করে দাও 5 minutes matter.
5 million for the respondent petitioner.
Mr. Shanna's matter is going on still, Lordship. Kindly, Lordship.
It was 5 minutes. No. Then
Lordship, Mr.
another-
Shanna was there,
I
Lordship.
think another one came. Now you have been sent.
Lordship, she is also there, Lordship.
No, I do not find her.
No, she is calling Mr. Shanna outside.
Whatever.
Lordship. Lordship, kindly, Lordship.
No, sir.
Lordship,
No, sir.
Lordship, he is on his legs, Lordship.
Maybe. No.
With this.
In fact, this matter hearing was concluded, and we had shown a document to support my case that similarly situated persons were given the benefit. To that, Mr. Sanyal sought time to take instruction whether they have been given the benefit or not.
That is what I really wanted. Then
Yes.
if they have an instruction, then otherwise we will just conclude.
Lordship, kindly
Yes.
go through this. Shanna has prepared this.
আমাকে একটা কপি
Yes, thank you. Concluded.
Thanks. Deeply obliged.
obliged. তোদের ইনস্ট্রাকশন কোথায় লিস্ট অফ ডেটস
This is not list.
No, last
Preparation.
line he says not at
Lordship,
par.
Lordship,
Last paragraph.
something raised from your Lordship, that's why this is the answer.
Yes.
oh
Call the next.
obliged মানে great
CAB Lordship.
Has to be.
in appearance গুলো দিয়ে দিন সব
to assist your lordship as
Yes, Mr. Bhattacharya.
This is a deeming provision on which my lord wanted to, my lord, assist the honorable court. The issue was, lordship, can you recollect that after 5 years?
Are you here in Calcutta or where?
No, I am in Calcutta. I am not well. That's why my lord could not go to court physically.
Are you in a position to do the matter?
If your lordship accommodates me, lord, that would be better.
Because we wanted your physical
My
appearance.
lord, kindly, my lord, give me today's time. I got viral fever yesterday night. That's the problem.
Then we are keeping in the next week so that you can
My lord, my lord.
next Monday.
My lord, only one thing, 15th and 16th, Mr. Bhattacharya will be before the Supreme Court, my lord. I have been instructed on 15th and 16th, Mr. Bhattacharya will be before the Supreme Court.
But he has not.
No, my lord, probably, yes, my lord.
Can you unmute your system, Mr. Bhattacharya?
Lord, may it be on 12th, my lord.
12.
Yes.
Yes.
Item number 19.
My lord, 9.
Lord Dishike.
What is this application?
My lord,
We have decided not to hear out the main matter. We will only have dispose of the applications.
in this matter,
Unnecessarily-
my lord has heard this matter. Last occasion, my lord directed me to show a single incident that, my lord, one of the headmaster was transferred, where there was, my lord, single teacher in the school. Now, my lord, I have used one affidavit, supplementary affidavit, annexing the list of headmasters who have been transferred in similar situations. My lord.
You are not being benefited with the order. That means it is a worst case you have.
My lord,
If you could
Ma-
not
ma-
get a favorable,
that-
that means it's a worst case you have.
now I have a good case. My lord.
Oh, yes.
What is in the order, my lord? Kind
Yes, that's why I say worst case. Otherwise, the order would have been different.
different. That
Oh,
we can't go. আমাকে একটা copy দে। My lord, kindly come to paragraph 3 and 4.
no, this transfer of a headmaster can be done, but single teacher, that's a
My lord,
where
single,
you have stated here.
my lord, single post.
Where you have stated. I do not find from here. Paragraph 3. Simply say such and such transfer from this school circle. This is the circle. That's a single teacher or double teacher. I don't get it. I wanted that. There must be, you should show some document that this is what is.
The document I have annexed, my lord. Can you see the annexed, my lord?
Yes. Whose?
6, my lord.
Whose document?
My lord, this is the document of one Anita Mahato.
Anita Mahato is there.
Yes,
Anita
Anita Mahato joined Sampur Girls School.
Offline.
But where is the supplement? If you give me, supply me.
My lord, I have, my lord, I have.
But not the lordship, not directed to file any supplementary lordship.
Yes.
So why are I accepting here lordship? If the lordship not directed to
Lordship.
file the supplementary affidavit, why are I
Let us-
accepting?
Let us taste your conduct.
Yes.
If the lordship here and now lordship, then
No
lordship.
difficulty. That's the power
Lord-
under Order 41, Rule
No, no,
27.
no. I am in lordship without direction. Lordship sub the copy.
Anyhow,
But
we have
lord-
granted you a leave.
Yes.
Granted them. We wanted to see if it is
My
there.
my lord, now kindly
there.
come to the joining report. Anita Mahato joined Sampur Girls Pay School as a head teacher today. My lord, she was a head teacher. She joined in the post as a head teacher in that school, my lord.
No. Whether she was the only
Single teacher. All the
in the school.
in the school, my lord. In the school, she was the head teacher.
I think here in this case, the head teacher and there is only one teacher.
3 teachers.
In this,
Yes.
In
In
your
my
school.
case, 3 teachers.
so they say that if you are transferred, then
There will be no
only
head
with
teacher.
2 teachers.
2 teachers and there will be no head teacher.
Correct. And this was a case, Anita Mathur.
Single teacher.
Single means?
না অন্য আর টিচার ছিল yes মানে there were also my lord one or two teachers where
One or two teacher will not do. You have not stated in your affidavit. You have not. You are what you are arguing, but you have not stated anywhere in your
yes,
petition, supplementary affidavit, that in case of this Anita Mahato,
my lord, not only Anita Mahato I have given the my lord entire my lord
where are the documents?
my lord three এখানে কোন document আছে my lord the only single document which I could collect my lord I have annexed one
But here, let's
But you'll have to say that this school, Anita Mahato was there in Nalkupi Primary School.
এটা কার
Whether it has only 3 teacher
কি
or 1 teacher or what? And
নামটা
1 headmaster or headmistress.
my lord if your lordship kindly come to my stay application at page 102
Yes.
a transfer order
Yes.
my lord kindly see
No, no, that you have shown.
yes here also a single teacher he has been transferred head single head teacher total assistant teacher 0 head teacher 1 para teacher 1 total student 47
Where do I get it at page 102, head teacher?
my lord the last just over here
That is AQ or something teacher.
head my lord it's head
But I do not find the
Yes, it-
document which you have.
আরে head এর HE টা কই
That is what I really want.
my lord kindly see page 62 it's the continuation of H and E my lord
62.
62 টা দেখো এখানে head টা
Yes,
দেখো
head teacher.
my lord same my lord but xerox my lord
Assistant teacher 1.
that is assistant teacher is 0
No, page 62.
no 102 62 I wanted to show that it called my lord it is said to be the head teacher now 102 my lord kindly come assistant teacher 0
And para teacher is 1.
para teacher is 1 head
Total
teacher is
student
1
is 47.
yes and head teacher is 1 even this person was also transferred
What is the name of this person?
the school is Bugora Primary School
Yes. What is the name of the head teacher?
head teacher naam my lord we could not get
Okay.
But Lordship, if the Lordship give me time, Lordship, I am submit anything, Lordship.
I will.
These are the bunch of documents where my lord will find that single assistant teacher, head teacher, they were all transferred. The entire branch. And my lord had the occasion, my lord, to go through these papers, my lord. When another writ petition, my lord, I moved before your lordship, my lord, the order I have annexed.
Where?
My lord, kindly see 116. যাকে ট্রান্সফার করলো একটা মামলা ফাইল করার পর যাকে ট্রান্সফার করে দেবো ছিল সাপ্লিমেন্টারি এফিডেভিট করলাম আমরা না অপোজিশন বাট ফর অপোজিশন একটু ক্লিয়ার করে একটা সাথে দেখা উচিত ছিল এখানটা লিখবি না তুই যা কি লিখেছিস এখানে
Now I'm bound by my own judgment.
yes
But Lordship, that judgment is,
Convince my brother if
But
you want to
that
take a
judgment,
dissenting
Lordship,
view.
I am coming, Lord.
If you want to take a dissenting view, then no difficulty.
Dear Lordship, that judgment is cited, Lordship. Bunch of petitioner, 160 petitioner was total. Some discrimination was there by the district primary school council. Some transferred, some
Here also,
favor, some not favor.
yeah.
Here, Lordship, no, here I'm coming, Lordship. If the Lordship says satisfied by your Lordship,
Argue before him.
some Lordship, he cited the judgment, bunch of petitioner, some petitioner is favor, some petitioner not favor. So the Lordship director, if the Lordship Article 14 is violate, Lordship pass the order if violation the Article 14, so they give the opportunity. That judgment has been cited by my learned friend. Earlier, Lordship division bench passed the order, my Lord Justice and division bench. Here, Lordship, only for 3 teachers is there, Lordship. 1 head teacher. Here he is submitted that document is cited the that earlier read petition. Kindly my say the learned friend, he give me some document where is the transfer order. Those document, which document is cited? Lordship, the earlier document, those read petition, he have to dispose the matter. Those document he was cited here.
the entire
Those document here, Lordship, some Lordship, here Lordship 2020-2024, some head teacher, some Lordship head teacher has been transferred in 2024. He is the promotion, giving the district primary council on the West Bengal district primary council pass an order. If the any teacher, assistant teacher, he is the promoted by the head teacher, that teacher has been transferred.
these are
Here,
not
Lordship,
transferable
yes, but here Lordship is the ratio is the 2 teacher. 2 teacher, kindly my affidavit in opposition, Lordship. My affidavit in opposition, Lordship, file a report. Is the rules say 2 teachers should be
already a
2
head
teacher.
teacher in Nagpuri and transferred to this school as a head teacher.
already a head teacher.
Head teacher.
Head teacher. Here, Lordship, is the ratio 150, above the 150, head teacher is there. 2 teacher, as per the rules, 2 teachers should be present at the time of the school, Lordship.
Oh,
If the
no,
one,
it was teacher in charge. Promotion and
here, Lordship, kindly see the Lordship transfer. Here, the condition of transfer. Here, Lordship, kindly see the.
এই জায়গায় ট্রান্সফার করেছে
Earlier decision, Lordship, taken the Lordship Article 14 violate. So Lordship passed the order. Here, Lordship, if the rules say, here 2 teachers should be present at that time, Lordship. Kindly see the rules, Lordship. Once a moment,
when
Lordship.
that rule is,
Rules is the condition of transfer,
I
Lordship.
am asking you, when the rule was framed,
Lordship, frame is Lordship, I said
much earlier,
2 Lordship, 15 June.
true. If that being the position, please come to page 102, 103, page 63, all these of the
all.
62,
But here, Lordship, I told
62, if you have, no, Anita, what he says is wrong. We are not accepting. Now we are expressing our mind.
but that,
Anita's case is different. Anita was the teacher in charge. She has been promoted as a head teacher.
no my lord it is a transfer
Sorry,
my lord she was transferred
please come to page 6.
Yes.
Look at it. And
as head teacher as per later
then,
transfer order
no,
give me supplementary, Lordship.
address, whom it is addressed, TIC,
But give me the supplementary.
Champuku Girls Primary School.
But give me supply.
she is joining at Sampur Girls Primary School.
No,
Yes, my lord. Can you see them? My lord, just the written Anita Mahato joined Sampur Girls Primary School as a head teacher. And my lord, it is a transfer order by memo number 22nd February 2024.
That Lordship transfer order issued by the head teacher, Lordship. Total Lordship, is the Lordship here.
oh, she was a head.
Yes.
But Lordship, here, Lordship, he just give me the Lord supplementary evidence, Lordship.
Correct.
And he in his
Which direction to
opposition, My lord, in his opposition, he has admitted that there are two teachers in the school.
Yes, but give me supply the
Then
supplementary.
the rule will not come into play, my lord.
Give me the supply.
Yes,
That
yes,
lordship,
I-
I'm taking instruction, lordship. It's not part. Here, lordship, 2020.
Take instructions.
No, lordship, I'm not. Here,
Take instruction. Come tomorrow. Talk about page 6.
and there, lordship, I am,
Talk about page 6.
lordship, I am coming, lordship. Well,
No,
lordship.
don't come. Take instruction.
Yes, yes, I am taking.
That's
Here,
not-
lordship, 2023, lordship, District Primary School Council of the West Bengal. Promotion has been given to the head teacher.
Arey, no. Look at page 6. What you are arguing, that's why I say you have not seen that document. We were also under the wrong impression. Come to page 6. Look at the address, yours faithfully at the bottom. Who? She's already a head teacher of Nalpuri Primary School.
That I am taking, sir, tomorrow, lord.
And then left hand side, she has joined as a head teacher of Shampukur Girls. Is transferred.
And my lord, the paragraph
Head
3,
teacher was transferred.
paragraph 3, all these persons, my lord, were transferred as a head teacher.
Yes,
Being a head
has
teacher,
been-
transferred as
but
a head
after
teacher.
lordship, promotion has been given,
There
lordship.
is no promotion.
I am giving you, lordship, that,
Page 6, that's why
that I
I'm
am
saying.
saying. That,
Page
lordship,
6 is not a promotion. She was already a head teacher
All these
in
persons, oh,
Nalkupi Primary School.
that, lordship,
She has been transferred to Shampukur Girls Primary School.
and all these
Second.
persons are
Now-
the head teacher, my lord. They were
Second.
transferred as head teacher.
And now when he says that all were, then you will have to consult the document.
that, lordship, I am coming. That document I am.
Leave is granted to the appellant to file the supplementary affidavit disclosing the names of certain head teachers who were transferred to another school despite the said school having one or two teachers, the two assistant teachers. The said supplementary affidavit was necessary for the reason that the authority rejected the application filed by the appellant solely on the ground that there will be only one or two teacher in the said school.
Three, including head teacher.
The copy of the said the supplementary affidavit is served upon Mr. Vaishya in court today,
That's a, they are.
who submits that the matter may be taken up on other day to enable him to take necessary instruction.
এইগুলো। আর এই
Mr. Vaishya, you are for
I am for the direct, District Primary School Council Purulia, lordship. কত নম্বর?
the district primary school council Purulia
The respondent of 5, lord.
is
Five and
directed. No, can he say, or it's a school service commission can say?
No, not a school service commission, it's a board. No, transfer is the inter-district transfer in the lord.
clear, নাকি?
No,
Right,
only
yeah,
for the chairman.
Chairman.
Is directed to disclose. These are all within Purulia.
All every
Within Purulia is directed to disclose whether the transfer of the head teacher has been effected within the said district, despite the school is having one or two teachers, assistant teachers on the next date. Full stop. This is the matter on Monday.
And my lord, let him verify also. My lord, I have made, my lord, paragraph 3 and 4. 3, I have disclosed certain names of the head teachers, my lord, who have been transferred as head teachers. Can you see, my lord?
Very cryptic way of
My lord, yes.
supplementary affidavit.
But let's say I file a report, lordship. File a report on the basis of that. That is better, lordship. I am giving lordship. এখানে হবে না পাগলের মতো কথা।
Disclosure shall be made by the district primary school council Purulia in the form of a report.
কবে রাখছে?
Full stop. It goes without saying that the necessary documents in relation to the aforesaid head teachers as disclosed in the said a supplementary affidavit shall also be enclosed therein.
My lord, a advance copy of the report can be supplied to us, my lord.
Let us see.
Deeply.
Item number 20.
My lord, this for condonation of delay. Can 2 is for condonation of delay. Stay application. My lord, there's 118 days delay. Reasons I have stated. Reasons I have stated, my lord, yet under
Actually, 57 days delay. Our staff reporter has indicated 57 days.
57 days.
Lord, I have no objection if your lordship starts.
My lord, if your lordship kindly takes the order impugned, after rendering 11 years of service, my lord, he made an application for general transfer.
Why has to be allowed?
Yes, yes, yes,
Not
yes,
that
yes.
hard. It dismisses it.
Yes, yes,
Then
yes. I'm so
no
grateful.
question of going
Yes,
to the
yes, yes. Yes, my lord. I understand. Sorry. কি করে ক্যালকুলেট হলো?
Application for conduction of delay. The disclosure that there is a delay of
118 days.
108.
From the report of the staff reporter, it appears that there is a delay of 57 days. Is aboard the application that because of the medical issue, the father of the petitioner and the petitioner who had to undergo surgery at Bangalore, the steps could not be taken promptly for filing the the medical documents are also annexed to corroborate the statements relating to medical issues, which cannot be disbelieved. We thus find that the minister was elected by sufficient cause, if not preferring the instead of the application. The application is thus allowed. The detail filing the instead of the condoned, directed to be register the appeal forward. That can 1 of 2024 registered on Monday.
Grateful to Lord.
Monday.
আছি তো আমি আছি তো
Monday.
2022, sorry, 22.
এটা 20 ছিল 22
Scan 1.
যাও Lord, I am for the Central School Service.
Can one of the judgments keep effective? Can one stay? ঠিক আছে। But can one is a stay? Oh dear, what is that? The earlier judgment is already there. Notice portal suspended does not mean I have given that judgment. You have the copy of that judgment. Yes. We say that mere suspension of the portal does not mean that the entire thing is wiped out. They have to take a printout and then process. Yes, have you signed it?
Offline.
What is the, can you give the number? Write down on, come at 2, we'll give. Or if you can bring it, give the number.
My lord, only direction is required to the school authority to forward the application. Because my lord, school
What we
authority,
said,
yes,
that it will be routed, they will have to, and then entire exercise has to be completed within 2 months.
pass over করে রাখে।
Just pass over, we are doing it so that we can bring the file. Yes. Fine.
Item number 23.
pass over করে রাখো।
I am for the writ petitioner respondent. Can one restoration, condemnation of delay, my lord. Last occasion.
Date by Mr. Garland.
My lord, I'm appearing for. Ma'am, से बोलो जी।
Yes. 13.
No, 222. 222.
You will believe our staff reporter who is more accurate in calculating.
Sir.
Section 5. Madam, actually, online. It's online. So, yeah.
We have already done it. Other matters. We have simply say that the contempt would not be proceeded with until this Murmu's matter is pending before the Supreme Court. So let it be decided, and thereafter liberty was given to mention.
Fine. My lord, the one thing, my lord, the mat 233, the main matter, my lord, your lordship, my lord, granted the interim order till disposal. That is not uploaded, my lord.
What I'm saying, this has been done. The contempt proceeding has been initiated.
Yes.
Contempt, so that would remain straight for all time.
I'm grateful, my
আছে একটা ওদের কিনে নিয়েছে বিনা পানি রেফারেন্স একটা আছে
Stay হয়ে গেল।
রেফারেন্স তো আছে Can you give me the number?
My lord,
matter.
দুই সাথে দিয়েছিল দুই
নিচে নম্বরটা ফাইলটা নিয়ে নাও।
CPL contact.
Isn't it? What's the next one?
কেন এটা ধর
লিখতে দিলে
এইটা কেন 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 তেইশটা সেকশন 5টা ডিসপোজাল সেকশন 5 ডিসপোজাল 24
My lord, I'm for the appellate.
And the secondary board your lordship.
well I'm for the commission one ওই দরকার নেই ছাড়ো কিচ্ছু না আছে
You packet number
What?
My lord, if your lordship kindly takes 6th February 2024, the impugned order. Already there is a mistake in the yes.
কেন মানটা এই কাগজ করেছে
Same.
just give me.
My lord, only there is one wrong recording in the order. The second paragraph, commission has not rejected. Kindly see, the school authority has refused to issue NOC to the state prayer of the petition on the ground that she is a single subject teacher of the school. Consequently, the West Bengal Central School Service Commission has rejected the application of the petition. Yes, it is not there. So I am handing over two orders, the single subject teacher order and the Uchchasri portal order.
কেন মানো
Portal, they have to proceed on.
Very well. I'm offline. I'm handing over, my lord, the number. This is the order. Not only directs the school authority to consider it offline and complete the process as
এটা কোনটা?
Item number কত?
But in item 22, the same order will be passed.
যাদের সই হলো
very well, no problem.
Now it will be.
মানে 22, 23
22.
23 জানি না।
22 এনে দিয়ে দাও। 20 এই যে আরেকটা 22 24 দেয়া হয়ে গেছে।
Next one. এটা রাখো ভাষ্য দিয়ে
22, the same order will be passed.
22 কি অর্ডারটা হলো ডিসপোজ অফ হয়ে গেল তো?
They have said that hereby direct the applicant to submit the downloaded copy of an application from the said portal.
And a portal now at present, bullet portal.
Not there, downloaded. We have said. Downloaded copy you have. Also annex the document which form part of an attachment to the said application at the time of uploading the same.
document
When the portal was active to the school authorities within 1 week from date. The school authority shall take a consent decision on the said application and being satisfied shall issue a no objection certificate and also forward also the documents to the concerned DI who shall thereafter meet the and shall thereafter forward the same to the school service commission for making appropriate recommendations. It goes without saying that the authority shall strictly adhere to the statutory procedures and the norms provided for clear of the mechanism for processing the said transfer application. The entire exercise has been completed within 2 months from the
grateful, extremely grateful.
Malad directed the district inspector of school to forward the documents to the school service commission for appropriate recommendation. For appropriate recommendation, Malad.
That is what we said.
Recommendation means, Malad, recommendation for transfer, Malad. Then, Malad,
Yes.
school service commission ultimately, Malad, decides the issue, Malad.
That we have said.
Just go through once, man. If it is whether it is commissioner or commission.
Commission. What Saturday said, school service commission.
Commission, no? It's school service commission. Appropriate. হ্যাঁ ঠিকই তো আছে।
Appearing on behalf of state, my lord.
Recommendation, হ্যাঁ যদি হয় তো হবে। আগে তো ইয়াটা তো
24 22 24
next week 25 না?
The 22 and 24 similar order.
Uploaded.
হ্যাঁ 22
Not
22 আর 24
now. Very well. It will be beneficial to us because few matters
Because,
are pending.
my lord,
with a single.
it is on date.
Ball
On
hit
date
24
4th,
বলে দিয়েছে।
possibly the order was passed. So within 7 days,
My lord,
days have
7 days has
রাখি দাও।
on very
হ্যাঁ বলেছো সেটা তো অফলাইনে করতে হবে।
Similar issue, Malad.
Similar 22 and 24 similar issue.
Bola.
25
22, 24.
22 24
My lord, your lordships may be pleased not to take up this matter at this stage because it is pending before the Honorable Supreme Court. This is a 2016 SLST. So their appointment was challenged and it is pending before the Honorable Supreme Court. So my lord, kindly
Appointment
adjourn
was
this for sine die.
Where is that? Supreme Court.
নেই মানে appointment terminated by the division bench of this court. All appointment of 2016 has been terminated.
Yes.
That is under challenge of Supreme Court.
To adjourn is sanitized for the Supreme Court order.
দে
Now fight the
Kindly pass over করে নিয়ে আসবো। But kindly passes it over. I am bringing the order. Page 37 is my appointment.
এনে এটা রাখছি 10টা এখানে আছে সুপ্রিম কোর্টের টাই আছে এখানে আছে।
আমাকে চলে যেতে দাও, ট্যাবে দেখিয়ে দিচ্ছি ট্যাবটা।
Malad,
The order.
সুপ্রিম কোর্টের অর্ডার। 25
17th fixed
16th 16 তারিখ।
Tuesday.
যাচ্ছ
মামলা যদি হয় যেতে হবে, মানে ধর দেখলাম লিস্টে নেই, হয়তো এমন জায়গায় আছে মামলা ধরবে না, আগে থেকে জানা যাবে 2 দিন আগে।
ফেরার টিকিটটা কাটবে
না, ফেরার টিকিট কাটি না তো, আমি তো দিনের দিন সে কি হোটেল থেকে চেক আউট করে আমার এজেন্টকে বলি টিকিট এবার কাটি।
Was a downloaded copy.
Yes, I'm handing over my lord.
matter
And the matter is fixed on 16th.
16th
You are just keeping it passed over. You just give me a.
Yeah, I'm just এই বিবেক আমাকে একটা পাঠিয়ে দাও ভাই,
নাম্বার আছে তো?
এই ওটা পাঠিয়ে দাও
জুনিয়র তো আছে।
প্রিন্ট করে
হ্যাঁ হ্যাঁ, 2 PM করে নে, 2 PM যা। তাহলে we come back at 2 PM। না ঝুলে বসে থাকবে কেন, কতক্ষণ আর লাগবে পাঠাতে? আমার তো 31 আছে, 2 PM করিস না, 2 PM একটা ফিক্স আছে। হ্যাঁ হ্যাঁ, স্যার আপনি আমায় পাঠান, এই দিক থেকে আচ্ছা আমাকে পাঠান। ওর কাছে নেই, আমাকে একদম দিতে। আমি তোদেরকে পাঠিয়ে দিয়েছি, আমি দিয়েছি।
আচ্ছা
ঢোকেনি দেখছিস, পাঠিয়ে কোনো চলে গেছে না। পাশাপাশি থাক, আমার এখানে ঘরে মামলা আছে, আমি ঘরে পড়ে। হ্যাঁ নাম তো দেয়াই হলো, দেওয়া হলো না? হ্যাঁ 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 হ্যাঁ, কারণ আমার এখানে 31 আছে, আমি তো আছি।
এই অনুপমকে পাঠিয়ে রাখবে
অনুপমকে
কোথায়? 10 আমার মামলা? কি মামলা? নেই নোট, ব্রিফগুলো এখন এসে পৌঁছায়নি। ও তাহলে চলো না ঘুরে আসি। হ্যাঁ বলছি 10 কোর্ট পাঠিয়ে আছে বলছে। ট্রান্সফার নতুন, আসলে কি বিপুল এসে এখানে ঢোকেনি, আমাকে বলেছে মামলা আছে এখানে, আমার 31 আছে, ঢোকে আসে আসবে।
পাঠিয়েছে
10 কত চলছে? চল
চলছে বলে may we come back at
2 PM your lordship.
It will adjournment Saturday.
yes otherwise it is not proper my lord. So the reason for rejection is HRA. No, we are not entering.
So differently. If you take my view, the 2016 selection test was declared to be absolutely illegal, and it was paused. Meaning thereby, whatever the appointments have been done, those gone. They are out of service.
Yes
At the moment the Supreme Court has stayed the order,
yes
that means their continuation in the service remained. And the transfer being an incident of service, why
Yes.
not?
why not?
Oh,
It has got no impact so far as the only thing is appointment has been put at stake.
Yes,
Transfer, this is
so then
one way of looking at it.
yes
Another way, let us switch. That's the most safer course.
yes 16th is the
like
next
transferred and thereafter Supreme Court also.
No difficulty. They are
No
still
difficulty.
working.
Chalo, okay.
If they are working,
No, that person both get transferred.
wherever he is, if ultimately the Supreme Court upheld the order, that means his
Gone.
service gone.
Here or there my service is gone.
Yeah.
Yes,
Either at a A place or a B place or a C place, he has to go.
then my lord kindly passes that order.
all the teachers have filed one application.
Yes.
For your thought,
Yes. Possibly the impugned order before your lordship would prompt that more.
whatever.
That the HRA is the reason for not granting transfer.
In adjournment.
Another thing, my lord. My lord, transfer rule provides, my lord, if there is any judicial or disciplinary proceedings pending, my lord, transfer is not.
First, let him take his service.
Service, yes.
Then he can seek for transfer.
Yes,
Yes.
Service is unprotected.
Unprotected.
And judicial proceedings are also pending before the Honorable Supreme.
Item number
Any other proceeding pending for the Supreme Court apart from judicial proceeding?
No, my lord.
Have not come across any other proceeding.
No, ma'am.
apart from
Next.
এতে দিয়ে দেবো চাপ মুচ্ছে
26. Item number 26.
I am a conservative representative. I am filing my evidence. Still, sir, everything has been given to
I am saying question of notional benefits.
What is the meaning of the notional benefit? Notional benefit is that your service would be counted from an anterior date.
Yes.
Only for the purpose of computation of the pensions and for the purpose of if there is any further incentives or a decrease in the salary there, those benefits would be also given on a periodical basis. This has already been granted.
No.
That is an admitted position.
No. That
What are you
is my
talking about?
grievance. That is my grievance.
What
You
grievance?
kindly see their
But
report.
you will not get the actual payment.
Yes.
You will not get
Yes.
actual payment.
Your lordship kindly see their report.
What
I have
report?
annexed that.
Yes.
Their report. Yes.
Page 35.
No.
Page 35 report, right? Dada. 35 টা পড়া
Yes.
If your lordship kindly turn to page 39, they have filed the report.
Your lordship kindly, I request your lordship read 35, 36.
35 per.
Do that. No. না 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 57 26 কত নম্বর 57 817 ইন্টু 817 নম্বর 5 Well, notional benefit means basic pay and grade pay. My learned friend says, calculate dearness allowance from there.
Hear him.
Your lordship kindly turn to page 39. They are giving me area from September 2018 to January 2019.
Was approval was granted from 2018.
2010.
Approval was granted in 2018.
10. Pursuant to the order of the Honorable Court.
With effect from a notional benefit of 2003.
10.
What 10? Show us that when the
If your lordship kindly turn to page,
approval was granted in 2018.
if your lordship kindly turn to page 20.
What was the order of Justice Sinha?
Yes, then
It was
page 20. Page
7
20.
September 2018.
Like-
How can it be granted from 2010 when you did not serve?
Lordship kindly turn to page 20 first. The order of the Honorable Justice Amita Sinha.
Please
Yes.
show us.
In view of the aforesaid facts, and I am reading your last paragraph.
Accord a post facto approval of the appointment and accord notional benefit in a favor from the date on which the appointment was given to the other chief panel candidate in terms of the order dated 21st August 2003 passed by the Honorable Division Bench. Step to comply. What more?
Thereafter, your lordship kindly turn to page 22.
Yes.
Here, office memorandum.
Yes, 2018.
They have given 2018.
Has to be because 7 September.
But I have appointed 2012. I have originally appointed 2012.
Where you have been appointed?
I have appointed 2012.
Where you said that you were appointed? In
Yes, yes. I am stating, well, I have appointed 2012. It is not that I have appointed 2018. No, I have appointed 2012. That has been extended from 2010. Pursuant to the order of the Honorable Justice Amrita Sinha, notional benefit has been extended from 2010. I originally appointed in the year 2012. 5/11/2012, I was originally appointed. I have worked from that date.
There is the order of 7 December 2010. There is the order
That
of
is,
7
that is
December
in the
2010.
petition mirror. That is of the division bench order passed by the Honorable Chief Justice and
In
the
your matter,
no. That is the in overall mirror. With regard to panel, with regard to Howrah Council's panel, that is not my matter. That is, in that case also I was appeared because I was impaneled. Subsequently, I was delisted. Thereafter, pursuant to the order of the Honorable Justice Bhaskar Bhattacharya, my lord, as the lordship then was, my lord, he restored my. Then I was appointed.
Where is your letter of appointment?
In my writ petition. In my writ petition, that
You have annexed to us. Show us your letter of appointment.
here is the order of the Honorable Division Bench, passed in the year 2002.
Sir, I want to know where is your letter of appointment. To us.
Yes, this is my letter of appointment.
But I think that is at page 21 itself. If I'm not wrong, that's the appointment. তুমি দেখাচ্ছ না কেন 21টা দেখে নাও 5th December 2011 দেখো দেখো page 21টা দেখো ঠিক দেখাচ্ছি কিনা দেখো
5/11
তুমি দেখে নাও আমি ঠিক দেখাচ্ছি কিনা
appointment. 5/12/2011. Page 21 is the appointment letter.
1 minute, sir.
From 2011, December 2011, I was appointed and I was working since 2011 to 2018. Because I was working from 2011, 5/12/2011. According to the court's order, Honorable Justice Rai Chakrabarty has said,
We have given you an actual financial benefit from this.
7/9/2018.
That is your grievance.
My grievance is, I
That
have
is only your grievance.
yes, my grievance is mirrored.
Take your seat.
Number page 38. My lord, kindly see, my lord. When he was deemed to have been appointed 10th April 2023, 2003, notional. That's your losses, ROPA 98. That has been taken up to your losses. Kindly see, 1st July 2011. I think column 13. Then your losses from December 2011, he was in service. She drew the salary accordingly. So notional benefit which has been calculated and drawn that matched with that. So he got the salary from 2011 to 2018. And then 18, my lord, actual difference have been paid onwards by the order of the court.
2018, the actual difference.
My lord, 2000 actual, my lord, that has been marched with the pay. But the actual benefit, difference have been paid from 2018 by the order of the court.
Simple question. Court found that she was entitled to an appointment from 2003 when the internal candidate of that was appointed. She was not appointed. She was appointed in 2011, maybe on a purely temporary basis.
No, that's not actual. So clearly in written that.
From 2011, she is getting the salary. I do not know whether she is entitled to all other benefits, whether that was given to her.
That was given to her because he was actually working.
Just ask one after the from 2003. I do not know. I'm just out of sheer, I would say, inquisitiveness. I am asking you this question. There is a revision in the scale, or some incentives, some allowances are also given on the basis of the span of service. If a person has served for say around 8 years or 7 years or 5 years, then he is entitled to certain increment. True? If the total benefit from 2003, you may not have to pay the actual amount, but he is entitled to an increment.
Exactly.
For 2011, whether if she would have been in 2003 service, then the amount which she received from 2011 is amount. Other 2003 internal candidates who were appointed were getting the same amount from in 2011.
The amount is the same. I tell you, Lord, the difference.
Amount is the same. Whether I'm against it. Whether from 2011 certain allowances which the 2003 candidates who were appointed in 2003 were entitled to was also paid to her.
My lord, I tell you, Lord, notional benefit according to the government norms only includes now pay band and grade pay plus yearly increment, which is attached to the pay, not the dearness allowance or other allowances. Your Lordship, this is the point. We have one report.
How can you relate back to 2008? Why not from 2011?
I tell you, Lordship, here. There now the point remains. Now, 2003, your Lordships kindly see 3,150 basic pay that has been fixed. Now, your Lordships will find yearly increment every year has been added.
Where?
My page 38.
I'm looking at
Yes, Lordship. Pay
scale.
Pay scale. Now, your Lordship, scale, then date of appointment, and then actual pay.
So
Now, kindly
130 was given to her. 10,130 was given to her.
10,000, your Lordships. I'm not getting 10.
After this 1/7/2011, the date of appointment.
Exactly. Pay.
Amount is 10,130.
10,130.
Getting 10,130.
See, at that point of time, she was not in service. She joined, if I'm not wrong, December 2011. So this is notionally fixation comes, gradually goes down. Your Lordship with the increment. Then your Lordship, she joined first service. I tell your Lordship the date.
Let us see from
5th December 2011. Now your Lordship.
December, let us see what she's in.
She drew my lord 10,130.
In December. Then in next year, July, she's entitled to an increment of whatever. The total amount comes to 10,440.
440.
You can get this 10,440.
I tell you, Lord.
Tell me that in that event, whether she was entitled to a house rent allowances, suppose if she was there in service, was she entitled to a medical allowances, suppose if she was in service in 2003.
My lord, I tell you, Lord, all allowances are paid on the basis of actual service. my lord, kindly take the assistance of state, otherwise it is not paid. When the notional benefit is calculated, that is only on the basis of band pay and gate pay with yearly increment, nothing else. This will come to his last date.
You define notional benefit somewhere.
Notional benefit, my lord,
I'm simply asking. It's very new to me. It's very new to me. Now I have to amend it. That whenever I pass an order giving a notional benefit, I will clarify that whatever other allowances
he will not be getting, that's the instruction.
whatever the other allowances, whatever the
Allowances will be fixed, I tell you, lordship. I have narrated in my report. Allowances will be fixed. Allowance.
There should be something which is put down. Where is defined notional benefit?
Notional benefit has not been, in the law has not been. I
You of your own in a air conditioned atmosphere.
No, not in it. This is followed by the government.
You think that I will interpret notional benefit with
What I have done, kindly come.
Whatever is attached to the particular post that benefit.
That's probably not, your lordship. Kindly, my lord, then your lordship, my lord, I will come up with the, my lord, all other things.
Come with, if it is not defined, if there is nothing, come. If there is any judicial interpretation of the notional benefit, come and show us.
Do that, your lordship. No, sir, that's our report, your lordship.
Because he will be entitled at least from December 2011, not before.
December 2000? That this is not notional then. 11 is not notional. Up to 11 notional. Because he already in service. Join, because this is not notional.
It's a post facto approval.
Exactly.
That means that whatever the entitlement it could be continuing, and from the day when she actually worked,
get the actual pay. That's your lordship. He has got that. Up to the Malad and 5th December 2011, the total notional benefit calculated. I know.
Whereas 2003 candidates were enjoying all.
But because they actually worked. Notional means actually work. Otherwise, allowance you won't get.
Yes, but I know how to tackle this situation. How much, according to you, have suffered financial loss?
I'm coming.
How much you have suffered a financial loss?
Yes. I'm coming to that. If I appointed,
please tell me from 2011
yes,
till 2018, how much financial loss you have suffered?
Near about 2 lakhs.
2 lakhs.
Yes.
We are allowing your appeal with the cost in the same of 2.5 lakhs to be paid to you.
Along with interest.
Will you be happy?
Along with interest.
1.5 lakhs.
What I am saying, my lord, I should learn from your lordship. Only one thing. What is the meaning of notional benefits? According to me, I may be wrong, my lord, subject to your lordship's calculation.
From 11, there is no notional. That's actual payment.
According to me, my lord, that the basic pay and grade pay is the basic salary. Other allowances is called notional. So therefore, the gross pay minus basic pay equal to notional benefits. Well, I am coming to that. The pay band.
Small aside, very weird argument and interpretation that is coming from. Interesting interpretation.
No, certainly, if when I joined in the service, my contention is not when I joined in the year 2011, and the post facto approval has been given 2010. Generally my pay certainly enhanced in the year 2011.
Ooh, that is what they say. That I am asking. They say yes. And whatever the difference amount was, that from 2011 onwards, that they have paid, they say.
No, I tell you, losses.
2018, they have paid only from 2018.
What I'm asking from 2011 that has to be paid.
Not paid, 2011 to 2018.
Asking a very simple question, sir. All of you are jumbled up. I asked a very simple question, sir. Please open the shutter of your mind. Try to understand. A person who was appointed in 2003, he continued in service. What was the amount as salary he was getting in December 2011? I asked this very simple question. At least from December 2011, you are entitled to that amount.
Yes.
And if there is any increment subsequently, whether those increments have been paid to you. Both of you are arguing in a weird manner. Very simple question. We understand that you wanted an actual benefit from 2011, December. Not from 2003. This cannot be because you did not work from 2003. You are not entitled to any amount. Only for the purpose of length of service, it will be counted from 2003. That's
Only
all.
seniority may be given. Only seniority he has given also.
Seniority given. Now I clear to make it clear, losses. Actual benefit has not been given from 2011. Then your losses, this has been given from 2018 from the date of the order of the court. From the date of the order of the court.
Modifying the order and directive is to be given from December 2010.
The difference, because the difference you are talking about, if not already paid.
Yes, only I am paying for difference only.
Initially, we were astonished as to why the appellant has assailed the order passed by the single bench on 13/3/2024. But after hearing the counsel, hearing for the respective parties, we find that the appellant has a general nuance which need to be addressed in the instant. The basic fact stored from the record relates to an appointment as assistant primary school teacher in the district of Howrah. Wherein the petitioner was thrown out of zone of the appointment for the reasons which was not accepted when an approach was made to the court. Ultimately, the division bench on 21st August 2002 put at rest to all the litigations and directed that the persons who have secured more than cutoff marks, that is 34, are entitled to be included in the panel. The petitioner, admittedly, the petitioner secured more than 34 marks, but was not included in the said panel, which led the petitioner to approach the court.
Only subject to lordship's correction. Her name has been included, but subsequently deleted.
Ultimately, the petitioner was appointed as an assistant teacher on and from the month of December 2011. Yet, the petitioner felt aggrieved against the decision of the authorities for giving effect to such appointment from the date of joining the said post. The writ petition being WP 5900W of 2013 was filed before this court, raising such grievance as, according to the appellant, her appointment should be counted from the date on which the last impaneled candidate was appointed. The said writ petition was disposed of on September 7, 2018. With the following observation, page 20 पे quote करें. ठीक है. Apropos the aforesaid direction passed by this court, the petitioner was given a notional benefit on and from 10th April 2003 together with the financial benefits attributable to the said notional benefits were also extended to the petitioner with effect from 7th September 2018. The grievance still continued as the petitioner was under expectation to get the actual financial benefits from the month of December 2011, though the post facto approval was granted on 7 September 2018. The writ petition came to be filed, that is WP 24356 of 2019 before this court, raising the aforesaid issue. At the time of entertaining the writ petition, the report was sought for from the respondent authorities, which in fact were filed before the single report. Though it is indicated in the said report that all the financial benefits attributable to such notional benefits have been given to the appellant. But in course of the hearing, Mr. Sanya submits that such financial benefit was given from on and from the 7th September 2018. That is the date when the post facto approval was granted by the competent authority.
Malad, that was the Malad, they followed council, the date of the judgment of Justice Sinha. From that date they have given.
Oh, I have already indicated, sir. My very bad way of dictating the order. I have a very worst language which I cannot dictate it. I think I have got a worst way of writing an order or a judgment. I have indicated when the order is passed. The order under challenge is explicit to the extent that the single bench perceived the submissions / demands of the petitioner to be such that the petitioner is seeking the actual cash benefits on and from 10/4/2003, which she is not entitled to in view of the order passed by the single bench in an unreal round of litigation. The single bench does not appear to have addressed the actual issue raised in the writ petition. As the petitioner never, as the appellant never claimed the actual cash benefits on and from 10/4/2003, but from the month of December 2011, when she was actually appointed and was serving and discharging her duties as assistant primary school teacher. The report submitted before the single bench by the authority is galore to the extent that they interpreted the expression within court's notional benefit to mean the basic salary. Meaning thereby any other component of the set force or the service does not come within the ambit of the notional benefit. There appears to be a fallacy in the aforesaid stand of the state. The notional benefit would mean such benefits which if a employee is entitled from a anterior date, though not entitled to get it on an actual basis. It is for the purpose of the computation of the service, computation of the length of service, and all benefits extended on the basis of the tenure of rendering services shall be computed though not actually paid to such employee. It cannot be restricted only to a basic salary, but all other benefits attached to such post as the person who have been found to have done wrong reap the benefit of his own wrong. Any other interpretation would give a premium to a wrongdoer to deprive a person who suffered because of such wrong being done. And therefore, in our opinion, the stand of the state in denying the just and reasonable entitlement in the garb of interpreting the notional benefits in a conservative manner is not acceptable. The appellant actually served on and from the December 2011, but was not paid the other component of salary or allowances or benefits which he or she would be entitled had her actual appointment was made on 10th April 2003. The state respondent have paid all the financial benefits to the appellant from the date of an approval, post facto approval, and not from the date when the appellant was actually appointed. And therefore, we feel that such a stand of the state cannot withstand on the test of reasonability. We therefore modify the impugned order to the extent that the respondent authority shall pay the actual financial benefits in terms of the order dated 7th September 2018 on and from the month of December 2011 within 4 weeks from date.
Only one correction with your lordship dictated 10th February. That is not 10th February, 10th April.
Yes, said 10th April. My officer who take a dictation is more vigilant. Don't worry. Many a times he comes to the chamber and says that, look at the sentence, I believe it is not complete. So they do not just type like a robot. They apply their mind. Don't worry.
Well, only indicate that your lawsuits he has been paid salary from 2011 December. The difference will be paid.
Okay.
So kindly indicate that the difference upon fixation, the difference will be paid.
Taking one last, we modify the order. We can not stand up the thing. We modify the order. Modify the order. If the actual thing terms of the order dated is actual is actual financial benefit in terms of the order dated 2018 on and from months on and from the month of December 2000. that is okay. Now, potentiality that shall Jesus that that the appellant is entitled.
Means we have to rightly fix this. Fixes the right part of the
Has gone from 7 September 2018 and the differential amount
that should be paid.
shall be paid to the petitioner within 4 weeks. Yes.
Make the executive read petition.
Yeah, it reminds me of very interesting judgment of our High Court. Just
Dispose of.
Ojanath Krish. The court is judging.
Our.
Suit was filed for recovery of money on the ground of goods sold and delivered by a partnership firm which was not registered. Degree of section 69(2) was taken of the Partnership Act that if the firm is not registered, then it's not entitled. Since they found the difficulty in upholding the same, but could not succumb to his concepts that actually everything was proved that the money was given, and the goods was sold, they appropriated the goods, they did not pay the money. But because of the embargo, innovative idea was that dispense, but cost against the respondent to the tune of the actual price.
Well, actually, here, malnutrition clients will get the difference of the pay only, and nothing else. Four weeks. তোরা সাপোজ করি তো ঠিক কি না হয়নি না সেকেন্ড আপনি ঠিক করছি
My lord, the Supreme Court's order have found that sine die matter, my lord. 25 item.
Yeah.
It and
অনেক করে জাজমেন্ট রিজার্ভ হয়ে গেল না তুমি করেছে তুই বল বাবা কে গান শুনবি বসে জুনিয়র হয়ে গেছে টিফিন তো কোথায় হবে কেন কেন করবি কালকে পেয়েছি কি পেয়েছিস তোরা তোদের তোরা তো অ্যাপিল রেসপন্ডেন্ট ওরা রিট পিটিশন হচ্ছে আমরা অ্যাপিল করেছি কার এগেইনস্টে আমরা অ্যাপিল করি তাহলে এনআইওএস করেছি কারা তারা রিট পিটিশনের নাম না তারা লিড টু অ্যাপিল করেছে না কেমন দরকার তাই কর বলে দিন তো তুই তোরা চা আমার তো কোনো ইনস্ট্রাকশনের দরকার নেই। তোরা চা আমি সাপোর্ট করবো। বলে দাও in item number
So my lord,
27
sign a die and liberty to
Two will be. Yes.
in item number 27 where the respondent writ petitioner. My lord, last evening we have received the copy of the appeal. I'm praying for not this week, my lord.
এইখানে বিপটা এই যে স্যার আমি 15 থেকে
বলেছেন 25 হ্যাঁ পাসওয়ার্ড 4 নম্বর আইটেমটা বার করে এখান থেকে 4 নম্বর
First over matter, item number 25.
এগুলো দিচ্ছি
তুলে এনেছি
দিচ্ছি
হ্যাঁ ও কিন্তু ব্রিফটা আমাকে দেয়নি আমি কিন্তু জাজমেন্টটা ফেরত নিয়ে নেবো কপি নট সাব বলবো
Recommended for the how many 2018
18 pursuant to 2016 SLST.
not stated.
It is in the page 36, my lord, 36, 37. Page 36 is a recommendation subject. My lord, kindly take this subject, recommendation of candidate on the basis of the result of the first state level selection test for recruitment of assistant teacher classes 11, 12, 2016. Following West Bengal School Service Commission selection for appointment to the post of teachers for classes 11 and 12 in higher secondary schools, rule 2016. He is at 11, 12 geography.
So was the point. Clear. Selection is for the kids of the teachers. During the class 11 and 12, 2016. The batch of requisitions were filed before this court, challenging the state selected paper. State selection test for recruitment
রাজু দশটা দেখেছো রাজু দশটা
of 2016. Which were disposed of, holding that there has been illegality and infirmity to serve in said selection process, and the entire panel were paused and set aside. The matter traveled to the apex court in case of the state of West Bengal versus Boisaki Bhattacharya, Chatterjee, and others. Special leave to appeal, C number 9586 of 2024. By an order dated by an order dated 22nd April. No, not
No.
22nd.
22nd April is the division bench's order.
By an order dated 7/5/2024. The apex court admitted this special petition and directed the issuance of notice upon the concerned parties. The apex court also passed an ad interim protection that their appointment shall not be cancelled, subject to an undertaking to be given to refund the entire amount of salary paid between the date of the said order, the order and the final judgment to be passed by the apex court. Since the cloud has been created in the appointment of the petitioner / appellant, we feel that the matter should wait till the final decision is taken by the apex court. However, there is nothing. The matter is adjourned sine die. Liberty is granted to the respective parties to pray for enlistment of this matter after the disposal of the special lib petition, as stated above.
My lord, no, I'm not saying, my lord, as an officer of the court, I believe there is another matter where your lordship had passed the order, though it has not been served. He's also from this 2016, but your lordship
That
passed.
was not brought to our notice.
Yes, that's why I'm submitting, my lord, with all fairness, my lord. I leave it to your lordship. If your lordships want to pass the same order, then
I do not know what is that
Item
matter.
number
no, it is on 4th. It was disposed of.
And we don't have. Now we become functus of issue.
But it has not yet been served. So, very well.
Become functus
I
of
brought
issue.
to your
We can't
lordship's
do it.
notice. Yes.
Final order to be passed. Good. Last paragraph to we order है देखिए न्यू सुप्रीम कोर्ट ये अच्छे. Yes.
Item 4.
Have you taken?
Yes, yes.
What?
We contacted the school because I had submitted that after recommendation, the record is not with us. The headmaster has told us that she did not join. The writ petitioner did not join the schools.
She is out of service.
If after recommendation, if she has not joined, then
what?
Then she does not have any.
That's why I am
Yes.
asking. Service has been affected upon her. Delay has been condoned, then impugned order is stayed. But you have made a recommendation.
She was recommended, she was dissatisfied with the recommendation, she wanted a re-recommendation. That was allowed. That we are opposing because the rule does not permit any further recommendation once you have chosen the school in the counseling process. You have voluntarily chosen your school and now you cannot.
But here it is recorded in the order dated 24/2 that she accepted the appointment and is discharging her duty.
But we have contacted the school.
Can you give it in writing? Because look at the order. Look at the third paragraph. If you can, because that is the finding of the court.
Yes.
That's why if you can get it in writing.
But only the appellant had appeared on that date. That is the commission.
Whatever. So appellant is you.
Yes,
So you have, you might have submitted.
yes. So it
So bring in writing.
very well.
Bring this fact that she joined or she did not join.
In an affidavit, or simply I make. The difficulty is this instruction, whatever I am bringing, it is not from my own records. Once I recommend,
No.
I am
what is
functus
recorded
officio.
is that she accepted the appointment and is discharging her duty. That means she accepted
Must
and
have-
went to that school.
Yes,
Subsequently, she wanted to change her place, that the learned judge, in absence of the School Service Commission, did not choose to appear before his lordship. So that is why I wanted to know in the form of an affidavit, if you can, then it's better.
yes.
Leave is granted to the appellant to file an
Let me
affidavit.
just see the order once.
Please.
The date.
File
I
an
was-
affidavit, 24/2/2015.
যেটা লিখে নিন।
Leave is granted to the appellant to file an affidavit disclosing the fact whether the respondent number one, after the recommendation having made by the School Service Commission, joined the school which she opted at the time of counseling. In the said affidavit, now it shall further be the appellant shall further disclose whether she is still continuing to attend the school and discharging the duties in the school. Such affidavit shall be filed within a week from date. Filed.
My lord, kindly make it 2 weeks. The instruction I will take from outside sources.
I believed and understood that you will ask for 2 weeks. That's why 1 week was given, because lawyer always want a 1 week ahead, more time.
If it was within our office, I would have done it in 1 week.
2 weeks.
Next. Item number 27.
I have some difficulty today and tomorrow. He my lord informed your lordship yesterday.
Not today and tomorrow.
My lord, I am for the writ petition respondent. My lord, kindly adjourn for a week, my lord.
Not
I have to
this
take the
week.
instruction from the
Not this week.
develop.
But I am for the writ petitioner respondent. But I am for the appellant. But may I pray for 1 day accommodation? Because I am not feeling it. That is why.
My lord, one thing. On the earlier occasion, there is a direction to filing the affidavit in opposition. My lord, I have served them in May. They have not used their reply. If they reply,
I am submitting, my lord. As such, there is no such allegation against us. Well, this is a part of the order we have challenged before your lordship. Where a
You
huge,
want to do it,
wherein, my lord, huge
then
amount.
you are ready.
I am ready, but today I am not feeling well. That is why, my lord, I renewed my.
You started arguing on the merit. That's why I asked that you know everything, then you can argue.
Then if
Not
your lordship,
today.
then I
Not
place
today.
this matter, my lord.
Not
Yeah.
today.
learned senior is not feeling.
Yes, call the next.
29.
29, my lord, I am appearing for the respondent number.
I am for the respondent, my lord. Next to appear, my lord, for the appellant, my lord. My lord, this is also, my lord, the compassionate appointment matter, my lord. I have preferred and the content is, my lord. My lord, this is an afterthought, my lord.
Pani, Binapani Murmu.
Pinapani Murmu, my lord. Well, this is an afterthought, my lord.
Afterthought.
My lord, kindly consider the section 5, my lord.
Section 5.
Kindly consider section 5, my lord.
How many days delay? 284 days.
281 days. 281 days, my lord. 281 days.
Anyhow, our stamp reporter has said 284.
My lord, kindly come.
Just wait. Do not hijack their right to begin.
Sorry, my lord.
Have patience. We'll hear you.
My lord.
We have explained, my lord, the delay.
Just wait.
My lord. Yes. ভুলে যাও তোমার নাম লিখে দাও নিচে লিখে আছে অসুবিধা কি
Yes. After hearing the parties and on perusal of the amendments made in the application, that is Can 1 2024, we feel that an opportunity should be given to the respondent to deal with the amendments made therein. Accordingly, the respondents are directed to file affidavit in opposition to the said application within 2 weeks from date. Reply, if any, shall be filed within a week thereafter. The application is made returnable 3 weeks hence.
Well, the affidavit of service be kept on the record.
এই affidavit of service টা রাখো ফাইলে।
Number 30.
লিখে দিও affidavit service file.
Yes, my lord, I am appearing in virtual mode, my lord. I am appearing.
I appear, my lord.
Yes, my lord.
Oh, one, my lord.
I appear for the state respondent.
I'm for respondent number 1, the writ petitioner in one of the writ petitions.
Who is the appellant?
I am the appellant, my lord. I am appearing seeking for 2 days accommodation, my lord.
For my lord, my learned friend starts, my lord. I have my lord, one, my lord, submission that I want to make. My lord, there were, my lord, 2 writ petitions, my lord, which were, my lord, disposed of by one analogous order. Now, my lord,
Writ petition filed by the same party?
Yes.
No, my lord, two different writ petitions. 2 different writ petitions. One of 2020, the other of 2024. Both, my lord, is
There is a difference between 2 writ petitions and the 2 writ petitions by the same writ petitioner. Tell me.
No, 2 separate writ petitioners, 2 different writ petitions. Both, my lord, disposed of by my lord, one analogous order. Now, my
Res judicata. Don't worry.
no, I'm not on that, my lord.
No, I understand.
No, my
That's
direct-
the heading. That's why I say.
My
no
direct
res
friend
judicata.
wants to say that there should be 2 appeal
he has
Why he will prefer? If the other writ petitioner chose that I am happy with the judgment, why he will?
No,
He will not.
Of course.
So, my lord, both the
One writ petition is of 2020.
Mr. Kaur, you know, if some of the party chose not to.
No, both the petitioners have made parties in this.
As respondents, my lord. As respondents.
Both the
Both the writ petitioners,
Constitution
Costan has been clubbed, my lord, and both have been added as respondents. The writ
You will
petition,
delete one.
we have that, my lord, they have to
will
indicate them, my lord,
delete.
I guess, which writ petition
Yes.
they want to appear, my lord.
Yes, tell me, they have taken a strong technical point. Tell us against which writ petitioner you want to.
Well, I seek for 2 days adjournment. I'm in Delhi. I will fix on Friday only. I'm praying for 2 days adjournment. Friday I will be there.
Not this week.
Friday.
No, not this week.
Friday, Friday.
Not this week. Yes, next.
31.
31, I appear for the appellant lordship.
Your lordship, Kohli Bhattacharya is appearing in this matter for West Bengal Board of Secondary Education, praying for a short passover, your
I
lordship.
appear for the school authorities, my lord.
Let them start. In the meantime, he will come.
So she is engaged in court number 19, your lordship.
Maybe he will start. He will take some time to argue. Let him come.
It was substantially hard by your lordship on the last occasion.
Not substantially hard lordship.
আবার ফিরে এসছে কেন? সাবস্টেন্সিয়ালি হার্ড আগের দিন হয়েছে তখন আবার কেন? আমরা তো বলেছি যেখানে স্টপ হচ্ছে তারপর থেকে করুন।
Firstly, lordship, the impugn order is at page 249 of my stay application.
Where is the certified copy?
It has not been.
Yes.
Lordship, we have applied for the certified copy, but we have taken leave from this honorable court to file this appeal.
I have seen that. Thereafter, I am asking you, sir, where is the certified copy?
I have applied for that.
এই ডিপার্টমেন্টে গিয়ে জেনে এসো whether it is alive or lapsed. তো এটা এখনো জীবিত আছে না ল্যাপস হয়ে গেছে?
10th of May, the order impugned was passed. And be led by.
Lord, the issue which calls for consideration before your lordship.
Whether those provisions have been followed or not.
First is, my lord, whether before deciding to initiate a proceeding, my lord, under the Sexual Harassment of Workplaces Act, my lord, there has to be something which is known as a preliminary inquiry. I need not, my lord, address your lordship on that. My lord, the complaint was not handed over. The complainant was.
Why you did not raise when you wrote a letter to them?
That letter is
He is
just,
seeking extension of time.
that letter does not say that I will participate in the proceeding. That letter
Ask
cannot be
for
construed.
extension of time to file reply.
Yes.
So that has been construed by the single bench that you should have raised in that letter that I am unable to give my reply unless you provide me all the documents.
The documents, whichever is there on record, I invite your lordship to two things, I stop. Bangla resolution to the kindly comes.
Pointer now, point you should take.
To a resolution. Please come to 205. This is the ICC's meeting.
There are two continuous simultaneous numbers. We are grappling with that.
It is
the
my
top one or the bottom one.
205.
There are two numbers simultaneously going on. One page I could see 168 here, 213 here. Which one you want, the upper one or the lower one?
The bigger one, the higher one.
Both are the same font size.
202. Yes, your lordship is correct. It is my mistake.
The upper one or a lower one, page number?
Lower. The lower one.
Lower one.
202 kindly comes. 202.
Yes.
সভার আলোচ্য বিষয় পরিচালন সমিতির সভাপতির নির্দেশ অনুসারে 26/9/23 তারিখে প্রদত্ত চিঠি 25/9 তারিখে সভায় গৃহীত সিদ্ধান্ত অনুযায়ী 12/8/23 তারিখের পেশ করা রিপোর্টের তথ্য পূর্বে এবং বিশেষ পর্যবেক্ষণের ভিত্তিতে ব্যবস্থা গ্রহণের উল্লেখ সহ নতুন রিপোর্ট পেশ 28/8 তারিখে বিদ্যালয়ের শিক্ষিকাদের পক্ষ থেকে প্রধান শিক্ষকের সিকান্দার রবি দাসের যৌন বিকৃতির অভিযোগ বিষয়ে রিপোর্ট প্রদান বিষয়ে সিদ্ধান্ত গ্রহণ রাজবল্লভপুর উচ্চ বিশাখা কমিটির আজকের 10/10/23 মিটিং এর সম্পাদক সুব্রা হালদারের সভাপতিত্বে নিম্নলিখিত সিদ্ধান্তগুলি গৃহীত হলো। গত 17/7 তারিখে বিদ্যালয়ে বৃত্তিমূলক শিক্ষার শিক্ষিকা মৌমিতা দে দত্ত প্রধান শিক্ষকের বিরুদ্ধে বিশাখা কমিটির নিকটে যৌন হেনস্থার অভিযোগ এনেছিলেন। দিস ওয়াজ নেভার হ্যান্ডেড ওভার টু মি। যাবতীয় তথ্য প্রমাণাদি এবং শিক্ষিকার বয়ানের ভিত্তিতে বিশাখা কমিটির সদস্যরা এই সিদ্ধান্তে উপনীত হলেও যে প্রধান শিক্ষক সিকেন্দার রবি দাস তার পদাধিকার সুযোগ নিয়ে শিক্ষিকা মৌমিতা দে দত্তকে ক্রমাগত যৌন হেনস্থা করেছেন এবং মৌমিতা দে দত্তর সাথে অভিযোগ সত্য বলে এই সভায় মনে করে। রাজবল্লভপুর উচ্চ বিদ্যালয়ের কিছু শিক্ষিকাবৃন্দ পূর্বিতা পাত্র
বলো ওটাকে ক্যামেরা করো। Call the next.
But 32, my lord, on behalf of Mr. Bari, my lord, I'm praying for not this week, my lord. On behalf of Mr. Bari, my lord, I'm praying for not this week, my lord. Mr. Bari, my lord.
Bari.
Ikramul Bari, my lord. Ikramul Bari.
Three Baris, that's why I asked you which.
My lord, may I, my lord, only indicate, my lord, there is a condemnation delay application, my lord, of 37 days, my lord. My lord, my lord.
Also the ground of
My lord, that I am not, my lord, only the delay part, my lord. I'm grateful.
Not this week, my lord. Not this week.
Not tomorrow.
No, my lord.
Day after tomorrow.
Yes, yeah.
Great.
Item 33, my lord, I am appealing for the petitioner. My lord, actually, due to some medical urgency, I am out of station. My lord, may kindly keep it on next week. My lord, from last 7 days, I am out of station, my lord. Item 33 for the petitioner, my lord.
What do you want, sir?
My lord, I am praying for actually not this week, my lord. On the ground of medical urgency.
Anyhow, not this week.
My lord, I'm grateful, my lord.
34.
34, my lord, I beg to appeal. 34, my lord, I appear for the appellant.
I am for the state respondent.
Appeal application stopped.
My lord, the petitioner before your lordships is one part-time school teacher.
Can you take just
I'm
just take a seat? Let us hurriedly go through the impugned order. Contractual teacher. Have you terminated his service by giving a letter?
My lord?
He claims to be a contractual appointee.
Yes.
Have you terminated by giving a letter?
My lord, the rules, my lord, rules govern, no, my lord, rules govern what he is claiming that.
No, he is saying that there was some criminal case against him.
Yes.
He has obtained bail. He was there in custody.
Yes.
And after that, he wanted to resume his services. You are not permitting him to resume services.
Because
now the learned judge has said that since the nature of the allegation in the criminal case is very serious, so no relief. But only thing is, it's even if it is a contractual appointment, you have to terminate the contract. Have you terminated the contract?
My lord,
the contract has come to an end.
Yes. My lord, here, my lord.
Tell us.
Oh, my lord. My lord, he was absconding due to criminal case. My lord,
whatever is the reason, sir.
Deemed termination. That is deemed termination.
Absent. Then
deemed termination.
Terminate the contract.
Deemed termination, my lord. Deemed
Where is the provision for deemed termination?
There is no provision. He is relied upon the rules.
Can you imagine some deemed provision? Tell me, can you imagine some deemed provision? You are a statutory authority, sir.
Yes, my lord.
You are supposed to act according to law.
My lord.
How can you show me that there is a rule which says that if you are absent for 1 month, deemed termination? No difficulty. I will accept it.
Then, my lord, I have to, my lord, file there, my lord, the guideline by which they have been appointed. I have to file it.
What guideline? Where is the appointment letter? Have you annexed?
Appointment letter is annexed P1. No,
Page, tell me.
Page.
Yes, my lord. Page 36, annexed P3.
Page 36.
Yes, ma'am. And now it is, my lord,
for teaching in English.
Kindly comes to 37.
On purely temporary for a period of 1 year or what?
Yes, ma'am.
Is missing, is illegible.
For the date of.
For a period of 1 year, actually. It's not legible.
And thereafter, it was time to time extended. Kindly comes to the next page. This is the now ruling circular. Their age is up to 60 years. They are entitled to work.
Oh, that is
All of them under this GO government order. My lords.
Page 37.
so. How can you, unless you terminate it?
My lord, may I be permitted to, my lord? I'm on behalf of the headmaster and secretary, my lord.
You have nothing to say.
They are the ultimate controlling authority. The headmaster and school is
Termination of the service. Who can do?
the
Or headmaster.
headmaster.
And
They,
secretary.
You
he's
can only forward. And ultimately, you have to take a
ultimately
decision.
yes.
That's why I'm asking a question.
Page 120.
Termination, tell us.
125. Kindly have a look.
Please.
Resolution.
What's the statutory provision? No problem, sir.
Yes, my lord.
My lord, the petitioner.
Just 1 minute.
My-
Let him.
And then, my lord,
Page
Yeah.
120.
125.
Last page.
Yes.
on the last service related matters.
What?
12. My lord,
During the period
during
of
the
engagement, the service of such PTTs.
No, this is not for me.
part-time teachers.
Colleges kindly comes to 122.
It's for colleges.
Yes, my lord. Thereafter, my
He relied upon
no, I kindly comes to
Where?
case 122.
Excluding the superannuated teachers of charges and university serving as PTT. It does not say college. Where do I get it?
It starts from 122.
The supersession of all previous government relating to part-time teachers of the government colleges.
that is not. My lord, kindly.
This is the government.
My lord, relevant one is one.
It is not in the college.
Yes.
Then how it is applicable?
My lord, I have annexed that also, which is governing the.
But it says that may be terminated because of the involvement as may be framed from time to time by the competent authority. There is no
My lord,
guideline which is framed. Nothing.
My lord's 139.
I have to.
That
I
is
have
my
to.
claim.
my lord,
139.
because before the read code, I could not get any my lord, chance to file opposition. So my lord, I could not. So I
Yes,
have to take
139
instruction. I have to take instruction whether
What
my
is
lord,
this?
My lord, that is West Bengal Board of Secondary Education appointment, confirmation, conduct and discipline of teachers and non.
But you are not a regular teacher, sir.
for the
This
this
does not
is the-
apply to you.
Yes.
You have not.
My lord,
So in that event, you can't take advantage. You are, as a contractual employee, certain protection up to the age of 60 years is given to you on a basis of a lump sum annuities.
my lord, it's only one humble attempt. That definition of teacher, if you're once, if you're
Nothing. You can't take advantage of this.
my lord, there it is stated that if there is confirmation, service confirmation, then he will be coming under this rule. My
But,
service was
but there is a provision for different procedures for appointment. Did you?
For regular employment.
Not.
He is relied upon this my lord.
Just he did not participate in a
Yes.
regular recruitment
Yes.
process.
Yes.
He has been appointed as a part-time teacher
But my lord, subject to your lordship's kind sanction, my
as
lord,
a
there is
stopgap measure.
relevant rule governing part-time excepting this one. So
No,
my-
man. No.
Sir, everywhere the entire
Yes, yes.
state is grappling, including us. Even a high court is facing.
My point is that it is not related to his service. No show cause was issued. My lord, because Article 21 your lordship knows some procedure is needed to deprive me of my livelihood. Unless there is some.
Something is to be done here.
Well, I have to my lord, substantiate my case by filing affidavit, or my lord, I will my lord, produce on the next occasion the relevant provision by which where the criminal case is pending, my lord, he should be treated as deemed termination. My lord, there is a provision, my lord. I will search it, my lord.
I was there for nearly 19.5 years.
Yes, my lord.
These things I have tried successfully many a times. You have to match only for the purpose of getting an adjournment.
No, my lord is asking that particular question whether I have any authority. My lord is yes, relevant question. Whether I have any authority.
With the hearing on that particular day.
Yes, my lord is rightly, my lord.
Prepared myself with
On that point, my lord,
argued, forget what I have said earlier.
my lord, on that point, my lord, just now, my lord, I do not have any answer whether the rule.
Thing you do not do, let us find out.
Find out.
Then you say there is a provision. I will show on the next day.
They must.
No provision.
I will search it, but I will search it. I will try.
I put is grappling with these contractual employees, the monthly workers. No provision.
But his prayer, my lord, he is asking for my lord, the rules for regular. That is, my lord, just now relied upon. His
Could be. I also feel. I think my brother will also join.
actually, my lord, school committee, my lord, taken steps and my lord. Yes, my lord.
Yes, a full budget rule for these kind of
Certainly.
You have given a certainty up to the age of 60 years. What you have done in this case, you know, you have fixed a very small remuneration, which is not incommensurate with a regular employee
Yes.
of a group D.
Yes,
We
man.
are getting much more
Much more.
than them.
Yes, yes, man.
And then you say, up to 60 years, we have given, we will not terminate you. What does it mean? And then after the retirement, you say, I will give you a lump sum of rupees 3 lakh. What does it mean? This is what the mechanism is.
Yes, man. My lord.
Then you increase the strength.
Regular employment.
Do not put them in risk like this. Uncertainty, absolutely everywhere.
All contractual employees. Then, my lord, allow me one.
Absolutely prohibited. There is an act which says you should not you should avoid the employment on a contractual basis. When
one week time be given, my lord.
how much will stay? And think about it.
I will think.
We can direct the mandamus, we can issue a mandamus. Then you have to become rules of this thing.
My lord. Next is
35.
এইটা দিয়ে এফিডেভিটের সার্ভিসটা দিবে আছে
I'm appealing for DPSC manner led by Mr. Supriyo Chattopadhyay.
I'm for the appellant in this matter. Well, there's a condonation of delay of 5 days.
5 days.
Kindly see the report also, my lord. I don't know whether what days they have counted.
No, says in time. Oh, yes, these people do not. They do at least 100 times per day. So they are more.
Actually, my lord, we put it in this online calculator. There is an online calculator.
No problem.
That is the problem. Yes.
Section 12 is not known to anybody of the limitation. That's the only provision relating to computation of the day.
My lord, kindly dispose of this application. This may proceed.
There are many problems.
Oh.
Yes.
Respondent number 5 and 9, if the trial court has not been made party here, no, respondent
it is-
number 5 and 9 are not the parties in the trial court.
Yes, they are.
No, certified copy.
Yes.
Whereas the respondent number 7 and 9, who are the parties in the trial court, they have not been implemented yet.
My lord, I think this there is an up and down, I believe. District Inspector Schools. My lord, respondent number 5 and 9
of
5 and 9, respondent number 5 and 9
yes
means
of
district inspector of school, Paschim Medinipur,
yes
and the managing committee,
yes
Kajibagh Primary Schools, show us that they are there.
yes, my lord, district inspector of schools primary education Paschim Medinipur is the respondent number 4 in the page 86 of the stay application. And so far, my lord, 9 managing committee of the school. No, managing committee was not a party. It has been no. My lord, the school is there. School is there. Additionally, it has been made party, my lord. My lord, this is wrong because in primary school there is no managing committee. It has wrong. Kindly expunge that. I prefer expunging of that because it is SI. Managing committee.
What about the 7 and 9 in the trial court? This
Yes.
inspector of school is not made a party here in the memo. To us.
It's একটু গন্ডগোল হয়ে গেছে।
The sub inspector
No,
of school.
sub inspector of school is not there, my lord.
The 7 district primary school council, Paschim Medinipur is not available.
District primary school council is party. Dakshin Dinajpur is party.
Paschim Medinipur.
Paschim Medinipur. Yes.
দক্ষিণ দিনাজপুর
Not a party.
6 এখানে 7 হয়েছে।
Kindly, yes.
It is granted to the appellant to remove the defects pointed out by the staff reporter.
Yes.
Within a week from this.
দক্ষিণ দিনাজপুর 7 তো
Yes, yes. Today itself, right now. Right. No, if your lordship kindly grants me leave to add them as party, only I can add them, my lord. Kindly grants me leave to add them party respondents. Leave is required, my lord, possibly.
Before the answer. Go.
Very well.
Next one.
Navina. 36. The return. 36, my lord, I appear for the state respondent.
I'm for the applicant.
I appear on behalf of the West Bengal College Service Commission.
It's an application.
West Bengal College Service Commission.
It's an application
I'm
for
the state
condonation of
respondent.
10 days possible, subject to correction.
I'm not opposing this. 10 days delay is not. তাই আছে না।
It is vetted application. Which are not filled within stipulated period of time as enshrined in the act. The application appears to be allowed and disposed of. The correction.
Next. And one of the previous matter where the correction is needed, lordship has fixed, given any date,
Next week and
fixed any date after correction.
allowed next week.
Then I'll mention before your lordship. It is next week, right? It is next week, so.
Dispose of one.
Next week.
Can one dispose? 6 and 5.
37.
Well, I'm for the appellant in this matter.
Well, I'm the state respondent, but my answering respondent is the district primary school council Murshidabad.
No, this is an inter-district.
For the district council.
কোন অ্যাপিয়ার করছে? কোন অ্যাপিয়ার করুন?
ডিস্ট্রিক্ট প্রাইমারি স্কুল কাউন্সিলটা হয়েছে দেখেছো? ডিস্ট্রিক্ট প্রাইমারি স্কুল কাউন্সিল এটা কি ইন্টার ডিস্ট্রিক্ট না ইন্ট্রা? ইন্ট্রা ডিস্ট্রিক্ট বোর্ডের বোধহয় কিছু।
Apply afresh. Why you are not?
My lord,
What is this?
my lord, this is, my lord, I made this application, my application at page 64. Yes, my lord. My lord, this is an application
What?
under any other grounds of Rule 4. But it has, in my humble submission, with deepest humility, my lord, it is not under, oh, I'm sorry, 3E. My lord, the rule is at page,
Ground. I just wanted to know.
my ground is any other ground. It's a miscellaneous ground given in the rule itself.
Now, specifying what comes
Distance,
ground. I just wanted to know.
distance,
This is under Rule 4.
Rule 3. Rule 3E. That is secondary. This is primary. In primary, it is perimeteria. Similar rule. Verbatim same, but it is ground is distance. That is page 64 is my application. No. My lord, is my respectful submission. There is one and miscellaneous ground, that is any other, under which I can make such application for any other grounds that can be covered. Now I have this distance between my husband's workplace and my workplace, my child, and the distance from my residence to school.
So all the 4 corners of the state.
Lord, under this rule.
Distance of my child, my husband, myself. That means all the corners of the island.
That is why this.
You are spread over. Your husband at the eastern side of the state.
Yes.
Your son is in the western side. You are in the northern side.
This is the
Who
situation.
left for on the southern side? Correct.
My last hope possibly is there to go. My lord, kindly see the rules. If your lordship kindly takes rule 3E at page 60. That is why the state has promulgated this provision, specific page 60. 3E. There is a miscellaneous ground which I can access. So this is any other grounds. My lord, I tell you, lordship, under this ground, I made this application. Now this.
Where is your residence and where which you are?
My lord, my residence is at Nodia, district Nodia,
You are posted.
Murshidabad. Murshidabad, I am posted. My lord, my application has already been forwarded by SC to the DPSC. It is pending before. Now it is 120. Husband is located at Kolkata.
Wanted nearer to your residence, from Nadia. Again from Nadia to
I'm seeking, my lord, Nodia. I'm seeking, I want to go back to my residence at Nodia. Nodia, I want to come back.
There in Kolkata.
In leave, because that is my residence at Nodia. Nodia, I want to come back from Murshidabad. My lord, the rule allows me that. That is why I have come. But I tell you, lordship, with one reference. My lord, this ground has been considered as a special ground. Distance has been considered as a special ground by the Honorable Coordinate Bench and allowed special transfer in perimeteria rule 4 of the secondary. Yes.
Asking, what is the there? Because your husband would not be there.
I can take care of.
How old the child is?
Child is 5 years old, my lord.
Not that
that is
require a very expertise.
No, my lord. The persons, the husband is in a transferable job. He is there, my lord. She is staying alone near the school with the child. That is a difficulty. At Murshidabad, she is staying alone with the child. So if she can come back to her residence at Nodia.
Who is there in your residence at Nadia?
Family members, my in-laws, my family members, in-laws are there. That is why I want to come back so that the child can be taken care of properly. And I can render my service both to the school properly as well as to take care of the family. Both the obligations can be met out, my lord, if I am transferred to that location. That is a simply I'm seeking. And my lord, I am seeking also want to come back, want to go somewhere where there is a need of teachers.
Has
Yes.
more actual experience.
Yes, yes, absolutely.
Yes, sir. Good schools are there in Murshidabad.
It is not about having bad schools. There is nothing called bad school. In my respectful submission, all schools are good. Even wherever I want to go, there is also need.
Better school is in Murshidabad.
Then,
I rephrase that.
then my lord, I humbly,
Better schools is in
then my
Murshidabad.
lord, I humbly submit. I should go to those schools which are not that better and make them better.
No.
If I can submit in this way, my lord, if there are not better schools over there, my lord, where I'm going, there are vacancies where there are need of teachers. That is why I want to go there where there is a vacancy. It is not that I'm being added as a teacher. Over there also there is need of teacher, my lord. And my lord, only one thing, it has already been forwarded through SI to the DPSC. It has been allowed by the SI sub-inspector of schools and has been sent to DPSC. It is pending with the DPSC. Since it was pending, I came before this honorable court.
Well, I have not received any, well, as of today. Well, Mala. 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 First paragraph. Mala. First paragraph of
70.
first paragraph. Observation, anything, Mala.
What is it? State what I need.
My lord, the only two things, my lord. My lord, this, as of today, my lord, there is no application before the board.
Oh, sorry, paragraph first and
Two, my lord.
one and two. Sorry, student joining. Sorry,
I understand what is fallen from your lord.
application for chance. Had passed was severe of the scrutiny. But the authority who has to take a further decision was showing an apathetic approach which constrained the appellant to file the instant resolution. To bring more clarity to the observation made here in above, comma, the application for transfer on the ground of distance filed by the applicant was processed in the office of the sub-inspector of school, and the same was further forwarded to the
Chairman, Murshidabad DPSC.
District Primary School Council, Murshidabad.
Murshidabad.
Chairman of the District Primary School Board, who did not take and who has not taken any decision as yet. The single bench dismissed the writ petition on the score that the ground assigned in the said application is not a good ground. Rule 3 of Rule 5 of the West Bengal Primary Education, within bracket transfer of teachers, including a teacher, bracket close rules 2002. Confers power upon the teacher to apply for transfer on the grounds enumerated therein. The said provision is quoted as under page 63. Clause E of sub-rule 3 of Rule 5 is an omnibus ground intended to be incorporated as the authority while legislating cannot conceive of all the situations. The expression, the applicant may seek transfer on the following grounds, unquote, has to be understood in a pragmatic manner and to be construed as the grounds which are expressly provided, including the grounds which may be termed as valid on a special facts. The purpose of incorporating clause E therein would be totally frustrated if the application for transfer is decided on the grounds enumerated under clause A to D. The judicial experience gains in dealing with the case exposes other grounds than the grounds incorporated in clause A to D. And one of such example can be given that the transfers are sought on the ground of distance and the inconvenience faced by a teacher in attending. The authorities have also taken a conscious decision treating the said incidents as a ground covered under clause E thereof, provided the authorities are satisfied that such transfer is warranted. Apart from the same, the court should stay away from discharging the duties and functions of the employer and should not usurp such power in exercise of under judicial review. The management and administration lies with the government, who has the constitutional obligation to establish school within the state to impart education to the children, and therefore it is the government who has to take a conscious decision whether the grounds of transfer appears to be plausible, reasonable, and required for the smooth administration of justice, smooth administration of the education system. Time and again, the courts have shied away from substituting itself in the armchair of the employer, and it is not desirable that the court should adopt such an approach. The grievance of the appellant before the single bench was in relation to inaction on the part of the chairman, District Primary School Council, Murshidabad, in processing the application forwarded to it by the sub-inspector of school, primary education. And therefore, it was unwarranted that the court should make an observation that the grounds assigned in the application for transfer is not a good ground and does not come within the ambit of clause E of sub-rule 3 of rule 5 of the aforesaid rules. The order is set aside. The chairman, District Primary School Council, Murshidabad, is directed to consider and dispose of the said application within 3 weeks from the date of the communication of this order. If necessary, upon giving an opportunity to the solicitor to appear before him. The entire access within 3 weeks. Consequently, the writ petition is also disposed of.
Hello, the rule says the inter-district transfer, it is before the board. Board has power. DPSC does not have power for inter-district transfer. DPSC can only forward it to the board. Then board will take the decision. The exercise to be done by the board. It would be.
Is there any decision to be taken by a chairman?
Yes, chairman will only forward. Forward. Only forward. Nothing
Chairman
more.
has to forward to the secretary of the board.
Board can he
Recommendation.
No, no, no.
now take any decision?
No, no,
Or
no.
ultimately, he's merely a messenger.
He's the authority for intra-district.
Merely a
Messenger. He's for intra-district. Yes. For,
Pass out the message.
absolutely. For
The chairman would have last year directed. The chairman DPSC Murshidabad is directed to forward the said application to the
Secretary, West Bengal Board of Primary
Education.
To the West Bengal Board of
Secretary, West Bengal Board of Primary Education.
Secretary,
Secretary.
West Bengal Board of
West Bengal Board of
Primary Education.
Primary Education.
within within 1 week from the date of the communication of the order. Correspondingly, the secretary of the said board is directed to to consider and dispose of the said application. If necessary, after giving an opportunity.
Yes, the opportunity of hearing, my lord, I need to choose the schools. If I am eligible, I need to choose the schools.
Go and opportunity of hearing where you will make your submission.
Yes. The whole process to be completed within, my lord,
Same.
3 weeks.
From the date of, within
Very
4 weeks from the date of the communication.
Malad, kindly 6 weeks, make it 6 weeks, Malad. Kindly make it 6 weeks, Malad. Because
That average is of 5.
Malad, no, Malad, I'm not, Malad.
When the state is appearing, they will never agree with the pay.
No, I tell you, Lordship, why. Malad, I tell you, Lordship, why, Malad. Malad, there are, my lord.
From the date of communication, 1 week, the order has to be communicated. At least 3-4 days they will require the order to communicate. And from there, 1 week.
Malad, more
and
than,
from there,
Malad,
4 weeks.
Malad, I tell you, Lordship, why, Malad, your Lordship can understand, Malad. Malad, more than 200 orders, Malad, considering and Malad giving opportunity of hearing to the petitioners are pending, Malad. Every day, Malad, we are, Malad, getting the order and, Malad, doing this work, Malad. That is why, Malad, unnecessary, I do not want to, Malad.
Time to short for it.
A reasoned order to be passed, your lordship has directed, possibly. A reasoned order has to be passed, my lord.
Arrangement is of the matter, matters are here, then why not? You already hold the wetlands without the matter.
My lord,
Authorities are not, my lord, so competent like the court, my lord.
my lord, possibly lordship directed them to, my lord, possibly lordship directed them to pass a reasoned order also. Reasoned order ache.
What is the law? What recent order? One sentence is the recent order.
My lord understands,
Elaborate.
my lord understands the departmental autocracy.
What is the law? Next.
Grateful to your lordship.
38.
Lord, there's a defect. Lord, there are 108 petitioners in the writ petition. One of them have preferred the appeal, but Lord, the others have not been made, Lord, even pro forma respondent. Kindly grant us that leave. We'll have to add pages because 107 names.
My lord,
The left out parties as pro forma respondent.
may I, my lord?
In the memorandum of appeal.
কাকে করবে গো?
কাউকেই পার্টি করেনি শুধু সায়ন্তন এসছে Sir, kindly see page 19 of the stay application.
Within a week from date.
My lord, only one thing, my lord. I am also, my lord, file, my lord, one leave to appeal in this matter, my lord. May I supply, my lord? And my lord, in my matter, my lord, I'm also praying for another thing, my lord. In this matter, my lord, my learned friend, my lord, make only the university as a party respondent. Late, my lord, West Bengal Nursing Council, and
That they were made a party in the writ.
no, my lord.
Then
But my lord, the respondent, West Bengal Nursing Council.
everybody who were a party in the writ petition.
I understand, my lord, but the competent authority is West Bengal Nursing Council.
Madam, that will be taken at the time of hearing.
But that point in time, I was not a party, my lord. So,
There one rule. They do, if we find that the university is a necessary party.
yes, ma'am. Yes, ma'am. করতে পারবো কি করে? এই দিক থেকে
So,
চেষ্টা
so we can exercise our power, no problem.
Yes, ma'am. Grateful, my lord. My lord, I will supply the number to the court officer.
39.
For the appellant.
Victory appeal on the state respondents.
There is a delay of, my lord, 92 days, my lord, for filing the appeal.
What is the ground?
In condonation, my lord, the illness of the appellant. Paragraph 6, 7, and 8. ও
আমরা বলছি 92
accounts credited in the application attract what was such and such are satisfactory. So there is a legitimate in allowing the application. The condo can allow a disposal of.
Application should be listed in the next Monday.
Before rise, may I seek your lordship's extreme indulgence, with an apprehension that I may be imposed with a huge cost, that tomorrow, one of my matter lordships fixed a matter, at 2 p.m. Tomorrow, I have some difficulty, may I be excused, for this week. This for this prayer, because the matter was fixed tomorrow at my instance, I'm seeking, I have some difficulty tomorrow, can it be,
We don't remember.
the matter, which main point of mental is being heard.
নম্বরটা দেখে নাও কি আছে বলছে দেখে নাও তাকে দিও না লিস্ট
আমরা নাম্বারটা দিয়ে দাও।
কবে থাকবে বলুন? কাগজের নাম্বারটা দিচ্ছি।
কাগজ ওখানে আছে?
কাগজ দিলে সুবিধা হয় না, নাম্বার লিখে দিতাম তাহলে।
দুটো জজ
দেওয়া যাবে না রেকর্ড। কালকে দেখো ম্যাথ 490 ফিক্স আছে দেখো।
আরেকটা করিয়ে নিও, আর দুটো করিয়ে নিও। চল
এটা কি আমার কাছেই রাখবে?
হ্যাঁ
ম্যাথ 490 দেখো। হ্যাঁ বলো। না বেরিয়ে যাও বেরিয়ে যাও। একটা পেজ দেবে নাম্বার তোমাকে দেবে। যাতে মেনশন করলে তুমি না প্রার্থনা করতে পারবে। এই নিন দাদা, এই নিন স্লিপ।